All right, Ms. Harmon, whenever you're ready, please call the case.
Good morning. Today is January 7th, 2021. The time now is 10 a.m. Today we're hearing case 2020-012 AP for Ivory Streeter of the Atlanta Police Department. Today, Ms. Sterling Eves will be chairing our hearing.
Thank you. Good morning, everyone. Can we have everybody introduce themselves, starting with the city, please?
Good morning, Madam Chair and members of the board. I am Allegra Lawrence Hardy, here on behalf of the city. I have with me Attorney Karima Lewis, as well as attorneys Rod Gansky and Lisa Haldar.
Okay, on behalf of the appellant.
Good morning, Your Honor. Lance LoRusso for Investigator Ivory Streeter and Ken Davis, who is an attorney working with me. I have Kim Rollich in my office, who is working our exhibits in case court feels a need to call on her to try to get some exhibits up.
Okay. Everyone, we have some housekeeping matters to take up. We do not need to do this on the record. I'm going to discuss procedure. So if we can go off the record just a moment. Has there been any effort to resolve this case?
There has.
We have the witness list, and the process of this hearing is going to be pretty much the same as in court. The burden is on the city of Atlanta, so the city will go first. They will present their opening statement, then the appellant will present their opening statement, and the city will call their first witness, and the appellant will have the opportunity to cross. After the city rests its case, then the appellant will go forward with the city crossing whichever witnesses they may wish to cross-examine. Please make sure that you turn off your cell phones, everyone. And we already have the NPAA and the NFAA in cities exhibits 1 and 2 respectively, and in appellants 18 together. Any objection, as you know, counsel, that you make, please wait for me to rule on, and of course give the other side an opportunity to respond. Now, before we start opening statements, are there any preliminary matters to be taken up?
Yes, Your Honor, there are two. The first is the testifying expert. The board has ruled on his admissibility and narrowed his testimony to exactly what he is able to testify to and what will be expected to be testified to. As a testifying witness, I would expect that he would be exempt from being from the rule of sequestration. I don't expect that he would be here for the openings or the closings unless Your Honor decides to allow everyone to listen to the closings, which is sometimes traditional. But so far as the witness testimony, as he is here to educate the fact finders as to matters that would be beyond their average ken, we would ask that he be exempted from the rule of sequestration for the purpose of hearing the testimony, so that when he testifies, he can better educate and expound upon issues, the reason for which he's here.
Ms. Lawrence Hardy?
Yes, thank you, Madam Chair. We would object to having Mr. Borden exempt from the rule, and largely because he has not been qualified as an expert in this case. And we, in fact, have grave concerns about the notion of qualifying him as an expert in this case. Looking carefully at the ruling that this board issued on our motion in limine, this board did set forth the areas where any testimony of Mr. Borden may come. It, of course, is limited to APD's policies and procedures, the appellant's alleged conduct on May 30th, and the related discipline. Given the narrow issues that this board has said they will hear from Mr. Borden on, and again, given our view that those areas are not appropriate for expert testimony and that he in fact is not able to be qualified for an expert under the standard, we would ask that he be sequestered under the rule.
So, Mr. LoRusso, what's the legal basis for him being excluded?
First of all, Your Honor, that is traditional, that an expert who is testifying and will testifying about matters that the court will be taking up or the board will be taking up, traditionally they are exempted from the rule of sequestration. And so far as the issues raised by opposing counsel, if he is not qualified as an expert, then he won't be testifying. So he is not a fact witness. So when it comes time for me to put him up, if he fails in his voir dire or the court decides for some reason he is not qualified as an expert, then he won't be testifying. So that issue is cured. So far as him being exempted without being able to hear the testimony and understand what he's trying to bring forward, his role will be severely limited in his ability to educate the fact finders here.
So, Ms. Lawrence Hardy and Mr. LoRusso, are we going to spend time this morning going through qualifying him as an expert? And the answer to that is, based on what I'm hearing, yes is the answer. So, Mr. LoRusso, you're going to have to prove he's an expert, and Ms. Lawrence Hardy is going to put you to that effort.
Well,
Yes?
I would expect, quite frankly, I thought the court had ruled on that. He's been accepted as an expert numerous times in federal and state courts, but if we have to do that, it won't take more than a few minutes anyway.
Well, and Mr. Gordon has also been excluded and noted by federal courts that he was not qualified.
He's never been excluded as an expert. His testimony has been limited, but he
He
has
is
never been
limited
excluded.
because he was not, in fact, able to meet the standards of Daubert in federal court. Obviously, the rules here are different, but we do believe that it is not appropriate for him to be qualified as an expert in this forum either, and we will certainly take him through that inquiry.
So at this point then, what's going to happen is, Mr. LoRusso, when you call him, then you'll have to satisfy Ms. Lawrence Hardy or me in lieu thereof as to his qualifications as an expert. But that also means that if he isn't already considered to be an expert, then he cannot be exempted from the rule of sequestration. So you've got him in a witness room until it becomes time for him to testify to whatever you want him to testify to. And if you want him to be an expert witness, you've got to meet the standard. You want to respond to that?
It's your judgment call, Your Honor, and you've made your ruling, and my response is I appreciate your ruling. I appreciate your listening.
Okay. Ms. Lawrence Hardy, any issue on that?
No, Your Honor, thank you.
All right.
I do have one
So-
other matter, Your Honor, I just would, for the record, renew our objection to the quashing of the subpoena to Mayor Bottoms. I'm just preserving that issue for the record. We really don't have an appellate court. There's no interlocutory appeal here. So I just want to put that on the record.
Okay. Any objection to that? Ms. Lawrence Hardy?
Madam Chair, I don't know that, Mr. Russo can put whatever he'd like on the record. This forum, this board has ruled, and we appreciate the ruling so that the mayor can get on with the business of running in the city.
Okay. Ms. Karima Lewis, we are losing you. That's good, upside downward. Do we want to take a moment, Ms. Lawrence Hardy, and allow her to,
If we may, just maybe 5 minutes.
okay, 5 minutes, see y'all at 10:14.
Thank you.
Okay. Ms. Lewis, I see you've joined us.
My apologies, Board. My computer fell into two people to the floor. My apologies. I am back.
That's quite understandable, and I'm glad you're here now. A couple of more things I left out in the beginning. I want to make sure that everybody knows, especially for the record. Hearsay evidence is allowed, as you're aware, counsel, and we will give it whatever weight we deem appropriate. The board can examine any witness at any time, unless the witness, of course, has been released. Want to make you aware of that. And then, of course, this is a 3-hour hearing, each side having an hour and a half to present their cases. Are we ready to go forward at this time
Ready for the appellant.
for the city?
Yes, Madam Chair, we are ready.
Okay, openings for the city.
Thank you. Good morning, Madam Chair, and good morning to board members Fall and Elamine. As I said, I am Allegra Lawrence Hardy, counsel for the City of Atlanta in this appeal. I know that you have seen over 40 exhibits on appellant's list and seen the 16 witnesses on appellant's witness list. And you've already considered the parties' pre-hearing motions, some of which concern the evidence in this case. We thank you for the time you've already put into it. Perhaps as a result, you've thought that this is a complicated case that will take a long time to explain. But that would not be right. This is, in fact, a very simple case, not complicated at all. It's the simple matter of an unnecessary or unreasonable use of force by an Atlanta Police Department officer, appellant Ivory Streeter, in violation of APD work rules, and his resulting dismissal from the APD. This dismissal was directed by the decision maker and the only relevant witness, former Police Chief Erica Shields. As we all sit here today in our respective spaces, this relatively quiet morning, albeit in a week when much has happened in our country, I think it's useful to take a moment to remind ourselves of the climate in the city on May the 30th, and to remember where all of us were back in May. 5 days earlier than May 30th, on May the 25th, George Floyd was murdered by a Minneapolis policeman, with the murder captured on video. I'm sure you remember seeing that video. That was the video that led to nationwide protests, including here in our city. And many of these protests turned violent, reminiscent of more than 5 decades ago after Dr. King was assassinated. People were angry. It was a volatile situation, and it was inflamed by the intense media coverage of every move of both protesters and police. In this climate, APD knew it needed to be on its best behavior, not deviating from the protocols or work rules as they worked to keep our city safe. Considering the backdrop of citizen protests against police brutality after the murder of George Floyd, de-escalation from the Atlanta police, not the use of unnecessary and unreasonable force, was required. Appellant Streeter was a sworn officer of the Atlanta Police Department with 17 years of experience. I will show you today his experience, record, and his training record, including recent training on de-escalation and use of force. Appellant Streeter knew when he began working that day that there was a sensitive situation that he was going into on May the 30th, only 5 days after George Floyd was murdered and he had been trained on how to de-escalate. But on that day, rather than de-escalation and best standards of behavior, Appellant Streeter used unnecessary or unreasonable force, including pulling a gun and using a taser against a young, unarmed, and non-violent man, Mr. Messiah Young. We will see body cam footage here today. Mr. Young, as you will soon see, was not one of the people throwing objects at police. He was not even taking part in protests. He was simply driving in downtown Atlanta with his girlfriend, Miss Pilgrim, using his cell phone to document the police arresting his friend and asking the police to let his friend go because no offense had been committed. The footage we will show you today is clear. Various officers intercepted the vehicle in which Mr. Young and Miss Pilgrim were traveling, and they did not de-escalate. Instead, they escalated the situation. They yelled conflicting demands at these students. They brandished a gun and they tasered the students. Appellant Streeter used force and discharged his taser at Mr. Young. You will hear today from former Police Chief Erica Shields. And she will tell you that on the next day, May the 31st, she spent multiple hours reviewing videos of this incident. Chief Shields knew that the city was a tinderbox, and she knew she had to make a swift decision involving Appellant Streeter, given the potential that the public video of the conduct towards Miss Pilgrim and Mr. Young would further inflame the city in an already dangerous situation. Chief Shields had the courage to take quick, decisive action to avoid our city burning as it has before. Chief Shields understood that yes, her Atlanta police force was working under very challenging conditions. They were having things thrown at them, and one officer in the city was hit by someone on an ATV, and that officer was severely injured. Officers feared for their safety. But Chief Shields also understood that the protesters feared for their safety too, and that the police are charged to protect protesters and indeed all citizens. And we as citizens greatly appreciate the protection that APD provides. The situation that night required protection, but it did not mean that police were allowed to deviate from protocols. Unlike citizens, unlike college students, police, like Appellant Streeter, are trained with protocols to de-escalate the situation rather than using a taser or pulling them violently from their vehicle. Under the Atlanta City Code, Chief Shields is the only decision maker on firing, and all of the other testimony you may hear today about how others felt about this incident is irrelevant. Under the code, it's her judgment and no one else's, either then or now, that matters. We believe that when the board sees this evidence, and especially when you have the opportunity to watch the videos, you will agree that there was unnecessary and unreasonable force and uphold the dismissal. To the extent the board has questions about the incident, we will bring Chief Shields to talk with you and tell you what her thought process was and how she used her expertise and judgment to make the decision she was charged to make as the leader of the APD. And we asked the board to consider how important it is for the chief of police to have that ultimate judgment and to ensure that it is not undermined, because the chief must have the ability to discipline officers to ensure protocols and work rules are followed. I would like to spend just a moment on the procedural aspects of the decision making. I'd like to start by stressing again, and you'll hear this from Chief Shields, that she viewed multiple hours of footage and watched various segments over and over. Even though nothing in the code required it, she investigated Appellant Streeter's situation with her own personal, thorough review of the relevant videos. The city, at the direction of Chief Shields, prepared a notice of proposed adverse action, Your City 1 exhibit, and delivered it to Appellant Streeter. I know that you've all already looked at this document, and you'll see that Appellant Streeter signed it. The NPAA provided a time, 6 p.m. on May 31st, for an in-person response from Appellant Streeter. The chief was available, but as you will hear, Appellant Streeter elected not to provide a response at this time, as was his choice. As set forth in the code section 530A, which is your city exhibit 6, in an emergency situation, such as the one that this city was in on May 31st, the adverse action may become effective immediately following the employee's response, if any. If the employee does not appear for whatever reason, the Atlanta City Code does not give that employee the right to choose their response time. If the employee misses the opportunity, the adverse action becomes effective immediately following the response time indicated on the NPAA. And the Atlanta City Code 114-526A, which we've provided at City 05 in your exhibits, provides that when the employee's presence impairs the effectiveness of others, action shall be taken to immediately remove the employee from the work environment. The Georgia Court of Appeals has interpreted this precise section to mean the APD police chief can dismiss immediately an officer whose actions affect the public standing of the APD, which Appellant Streeter's actions most surely did. And we cite here for you the Hanrahan versus City of Atlanta case, 230 Georgia App 67. There, the court ruled that on its face, the code allows for the immediate dismissal of an employee when his presence impairs the effectiveness of others. And there, the board's affirmance of a police officer's immediate dismissal was upheld. Here, in this situation, when the world saw that Appellant Streeter deployed a taser unnecessarily at Mr. Young, justice was demanded. Appellant's continued employment with the APD would have further degraded the public standing of the APD and escalated significantly the already volatile situation the APD was continuing to face each night. Just as in the Hanrahan case, immediate dismissal was authorized and wholly appropriate. In conclusion, I stress again that this case is a simple one. You won't need to watch hours of footage like Chief Shields did to see that Appellant Streeter was engaged in unnecessary or unreasonable force. He was subject to and aware of APD Work Rule 4.2.5.0, and he violated that rule in the incident with Mr. Young and Ms. Pilgrim on May the 30th. Chief Shields immediately and thoroughly reviewed the video of the incident the next day. She considered the backdrop, the context of what was happening in the city, and she acted quickly and courageously with bold leadership in a city that needed protecting. And she acted within the city code, and it's her judgment and her decision-making that are determinative in these matters. She terminated Appellant Streeter in compliance with the Atlanta City Code. And we ask, therefore, that the dismissal should be affirmed here and that Appellant Streeter's appeal be dismissed. Thank you.
On behalf of the appellant, Mr. LoRusso.
Yes, good morning. My name is Lance LoRusso. I'm an attorney, and I have the honor to represent Investigator Ivory Streeter, who you will see on the screen next to you. Ivory Streeter has 17 years of experience as a law enforcement officer, over 1,800 hours of certified training. In 15 years of service to the city of Atlanta, he received a highly effective rating on his evaluations 11 of those 15 years. He has a wife and children. He is a dedicated, faithful servant of this city. And he was terminated, and we will show that he was terminated without an investigation, in violation of nearly every applicable policy and procedure and ordinance. He was denied the due process that is guaranteed to him by the ordinances, by the City of Atlanta policies and procedures in 114-530, 114-532, 114-527, and others. What you will find as you look at this case is that it's not just enough to say, well, that was bad conduct, I don't like it, you're gone. The chief can feel however she wants, but the chief is a public servant too. And the chief is obligated to provide due process to the employees of the City of Atlanta, specifically City of Atlanta police officers. And what you will find is time and time again at every opportunity, the city denied that due process and denied an investigation to those officers. What you also will hear is that in one of the investigations that has gone forward, another officer who was on the scene that night was cleared. The policies and procedures of the Atlanta Police Department require an analysis of use of force or any allegations of use of force or any allegations of improper use of a conductive energy weapon. And a conductive energy weapon is a taser. A taser is a brand, kind of like Kleenex is a brand. So you're going to hear CEW, you'll hear conductive energy weapon. It's a taser. Anytime there's an allegation of misconduct by an officer in the City of Atlanta Police Department regarding a CEW, regarding use of force, it must be investigated by the Atlanta PD Office of Professional Standards. You'll hear OPS several times. And had that been investigated, you will find that it could have been done quickly, and you would find that, I think you will agree, and you will hear evidence that no policies were violated. In addition, you will hear that this was not treated as an emergency action. In fact, the notice of proposed administrative action has the box unchecked for emergency action, and nothing in that ordinance was followed. So we can't come now and claim that that was an emergency action. This is going to show that. And I do appreciate the description of the climate, but let's talk about what the actual climate was on the night of May 30th, 2020.
Go home.
We're going to try and make a wrap.
Mr. LoRusso, are you showing something from your exhibit list? Or can you identify what you're showing here, please?
Mr. LoRusso? Mr. LoRusso?
Sorry, Your Honor, I had to put, just pause that. In order to play videos, Your Honor, I have to mute everything and I have to turn my speakers off. So I apologize. This
Okay,
is,
Miss Lawrence Hardy asked a question.
I'm sorry, I couldn't hear.
Mr. Russo, can you identify what you're showing, please? Is this from your exhibit list?
These are clips of footage that was part of the video. Some of them are part of the videos that you showed. Some of this part of the news footage. Some of them are statements by the mayor, and as she is an unavailable witness, her statements are admissible under the hearsay exception. In addition, this is the environment that you discussed in your opening as to exactly what these officers were facing that night. This is just a video display as opposed to describing it in the context of words.
Madam Chair, we would object to any exhibits that are not on the exhibit list for which we did not receive notice.
Mr. LoRusso, I'm afraid I agree, because the issue of the mayor shouldn't even be a part of this hearing, number one. And number two, this is kind of a backwards way of getting in something that might not have come in otherwise, and that Ms. Lawrence Hardy didn't have an opportunity to object to. So if you'd move along orally and not via showing the video, that would be best.
Not a problem, Your Honor. Thank you. So the officers on the scene that you will hear, the officers around that car that were discussed in the opening of the city, represent 120 years of law enforcement experience. Not just 120 years of law enforcement experience, they represent a group of individuals that are fugitive investigators. They are highly trained, they train as a unit, and they were brought in that night, you will hear, as an apprehension team. So when there was a violation of the law, when there was a situation like the curfew being violated, and I think you will find very clearly that Messiah Young and Tanaya Pilgrim were in violation of the curfew and had at least 10 warnings to leave the area they were in. They were under arrest at the time they were contacted. That these were 120 years of experience converging to make these decisions. I think you'll find the city references very clearly Graham versus Connor. It references it in its use of force, and you will find, and that's one of the reasons we have brought our expert today to explain that context, you will find that the use of force was reasonable under the circumstances. It was very limited in its use of force, and that there was active physical resistance by Messiah Young, that he was under arrest prior to being contacted by Investigator Streeter, and in addition, he was reaching into his pocket, giving officers on the impression that he had a firearm in his front pocket. In fact, you'll hear from Officer Carlos Smith, who screamed, "Gun, gun, gun," 3 times during the interaction. Once you look at this, once you hear the facts, and once you examine the policies, you will find a couple of things. First of all, the chief does not have the ability to just fire someone. She has to follow the procedures. She has to do an investigation, and she has to follow the due process that is afforded these officers. The force used on May 30th, 2020 was objectively reasonable, which is the standard for the city of Atlanta, in light of the facts and circumstances confronting Investigator Streeter, her city policy, his training, national standards, and United States Supreme Court precedents as referenced in Work Rule 4.2. The city failed to properly investigate his actions because they never sat down with him or any of the officers prior to firing him to investigate. Looking at videos is not investigating. The city failed to properly investigate the actions in violation of at least 4 policies. The city failed to follow procedure during the investigation of the incident and the termination. And you will hear very clearly that Investigator Streeter was never given an opportunity to make a statement as he is required to have under the notice of proposed administrative action. The interaction was not recorded as it is supposed to be, and virtually every policy was violated in the termination of this man. So we are asking at the end that he should be reinstated. He should be given full back pay and benefits. And I think that at the end of this presentation, you will agree. Thank you.
Okay, for the city, call your first witness, please.
And Your Honor, I am not sure. Our first witness will be Chief Shields. And Madam Chair, if I may just have a moment, I don't believe she's in the waiting room at the moment. I'm trying to figure out, obviously, I'm here with you all. If I may just have just a moment to make sure that
Take a moment.
ready to be brought in. Thank you. I see that she is logging in. I don't know if there are technical difficulties. But if we can just have one moment, we appreciate your patience. Okay, I'm told we are having a technical difficulty. May I request 5 minutes?
Yes, ma'am. We'll see you at 10:45.
Your Honor, I understand, and I fully expect you to give them some time, but at some point, my witnesses were logged in at 9 o'clock and 9:15. This is the city's first witness. I would ask the court to be very restrained in how much time we're going to provide someone to move forward. This is city's only witness. They should have been ready.
Thank you, Ms. LoRusso. Unfortunately, none of us control the internet. And so when calls get dropped, this is the modern reality of 2021. We're all just doing our best with the internet, and it's as reliable as we have all experienced it to be. We certainly are not doing it to frustrate you in any way.
Okay, so you've already lost 1 minute. So now you're down to 4 minutes, Ms. Lawrence Hardy.
Thank you.
See you at 10:45, everybody.
Yes, thank you.
Okay. There you are, Miss Lawrence Hardy. Are you ready?
I am, Your Honor, Madam Chair. Thank you so much. And thank you, Chief Shields. Will we swear the witness?
I can do it. Chief, how are you?
Good, thank you. Good morning.
Good. Can you raise your right hand, please?
Got
Do
it.
you solemnly swear or affirm that the evidence you will give to this hearing will be the truth and nothing but the truth?
I do, yep.
Thank you, ma'am. You put your hand down. Please, before Ms. Lawrence Hardy gets started, would you tell us for the record your name and spell it, and then tell us what position you held with the city of Atlanta and for how long you were there?
Correct. Erica, E-R-I-K-A, Shields, S-H-I-E-L-D-S. And at the time of the incident, I was chief of police and I held that position for 3.5 years.
Thank you. Ms. Lawrence Hardy?
Thank you, Madam Chair, and thank you, Chief Shields, for your time today. Would you please tell us about your background and how you became chief of the APD?
I initially had started my career up north as a stockbroker, and I made a decision to make a career change and move south. I knew I wanted to police. I wanted to be in the city of Atlanta. And so I came on, as everyone does, as a patrol officer. And I spent probably the first 8.5 years, I believe, policing in Southwest Atlanta Zone 3, Southeast Southwest Atlanta Zone 3. I worked there as a patrol officer, and I also worked on what we call our FIT teams, a plainclothes investigative team. And we did all sorts of tactical type operations, plus traditional 911 calls. After that, I became a sergeant, a lieutenant. Both positions afforded me supervisory, different levels of supervisory authority in different zones. In between, I worked a couple of years in our department's internal affairs. When I made lieutenant, after I eventually led our department's planning unit, that is responsible for all the policies and keeping the city accredited. Eventually, when Chief Turner took office in 2010, I worked as his chief of staff, running and managing his office and all of the day-to-day activities that were going on in there. I did that for about 1.5 years, at which time I became a deputy chief. I was responsible for all the technological projects that the city was engaged in. From there, I shifted assignments. I was still the rank deputy chief, and I was responsible for the city's budget, background and hiring, personnel, training academy, 911. From there, I became deputy chief in the field operations division, which is the division that's responsible for all the 911 patrol officers. And from there, I made chief.
And you were selected as a chief of police during Mayor Reed's administration, is that correct?
Correct, in December 2016. And I worked with Mayor Reed up until he left office in December 2017. 2017.
And then you continued under Mayor Bottoms, correct?
Correct, yep.
And I know that you began as a stockbroker. Can you walk us through your educational background?
I did high school. From there, I went to St. Louis, Missouri, and got my undergraduate in international studies, which was political science and history. It was while I was a police officer that I got the master's in criminal justice. So that pretty much sums it up.
And what year did you get your master's? Do you recall?
No, maybe 2012, maybe. I would have, for to be accurate, though, I would need to look on my resume. I'm sorry.
Okay. Were you the chief of police for the APD on May 30th and May 31st, 2020?
Yes, I was.
And what is the job of the chief of police?
I mean, ultimately, you're responsible for the organization, and so even though you may not, obviously, you have people working for you and executing on daily activities, you are responsible for the performance of the organization.
I know that there are many, but can you give me a few examples of your accomplishments during your tenure as chief?
You know, it was, for me, it was, I'm really grateful that I had the opportunity. I think when I came in, I know that Mayor Reed's marching orders to me were get violent crime down because it had been a real problem in 2016. And so one of the things that I did was I reconfigured how Apex, our tactical unit, operated. They were focused about being out in the street, but when you drilled down on their arrests, they were all over the place. And I made their mission very simple. You are going to get guns off the street. And I don't want to see misdemeanor arrests. I want to see felony arrests. That is clearly what is driving our violent crime. And so over the next 3.5 years, they did. We beefed up the unit. The first year, our gun seizures were up triple digits. Second year, double digits, and the third year, single digits. And our felony arrests were up proportionately all 3 years as well. And so that to me was really huge because at the end of the day, it made a difference in the safety of Atlanta. So that was something that I'm grateful for. I also feel as though one of the things that was really important to me is that the police department understand and officers start. Policing is past a crossroads. It's behind, and which is why we're seeing what we're seeing. And everything we do as police is based on the premise of when the officer engaged in forced decision making, does it adhere to the case law apply to it? But what we don't do is we don't look at the decision making that occurred by the officer that led up to the force. In other words, did you have alternatives? And so for me, it was really important to try to get that paradigm shift in place. And it started with Officer Green. I think it may have been January 2017. I'd have to look. And he's a good cop. He's a good cop, but he took it on himself to try to get someone in custody to punch this person repeatedly. And the reality of it was there was 4 officers watching him. And so my position was that given the totality of the circumstances at the time, that there were alternatives. There were other ways to diffuse the situation. So very early on, and that may not sound like much to y'all, but that's a huge cultural shift in policing because we typically look at the force at the minute it's used, and we don't take into account the officer's decision-making leading up to the force usage. And that is the crux of where policing has to shift if we're ever going to make gains in our most challenged communities. So I think we really started as a department to really embrace a use of force training going to another level. And that was huge for me as well. I mean, the department is extremely talented. And for me, it was just an honor to get to serve with all the people and to put them in positions where they could best succeed because it's a really strong department.
And how did you drive as the leader this paradigm shift? I know you referenced maybe tweaking training. Are there other things that you did to really drive this shift?
What you have to do is it's communication, it's constant messaging. So yes, you start with the training academy, and it was difficult. You know, I met resistance at the training academy in 2017 initially. But you just have to keep messaging it. And it's what I find is it's essential that you don't just message to the commanders because they won't necessarily, they should get it down to the troops, but they don't always. So for me, it was really important to communicate with the officers. So that for me, it was always about really talking, engaging with the officers, and also on critical incidents, I would send out an email because I wanted them to understand the totality of the circumstances that led to the decision making. Because I think information is the most critical piece, and ensuring that they were getting the correct information was paramount. We also really tried to lean into getting instructors to different speakers and instructors and thought thinkers to teach, particularly, excuse me, at our supervisory level. So it's constant messaging and reiteration of it. And then of course, with the body worn cameras, when we finally got those up and running, to me, that's an incredible tool because you can see what your officer's doing when they leave the precinct, what have you. And it's not a matter of trying to say, gotcha, but you do need to ferret out those behaviors and those tactics that are not aligned with what the department is training. And so when body worn cameras came about, to me, it was an incredible tool for us to improve our performance. What concerned me was the feedback I got was because we were requiring supervisors to audit the officers. The feedback that I got was just how great we were doing. And I knew, being a cop myself, I knew there was no way that was the case. Cops resist change. And so I went to the city's auditor office and I said, please audit us, because to me, it was really critical. If we were deficient, we needed to fix that before there was a critical incident. And so they came back with a pretty hefty audit. And it said what I expected it would say, that our people were not in compliance to the levels they needed to be. And so I created a body worn camera unit, which it's not ideal. I don't want cops and having to assign personnel to do this, but it is that important. And they would audit the supervisors to make sure that they were auditing, and they were auditing all of the officers, not just the ones they knew that would be in compliance. And where there were discipline infractions, we centralized the discipline, because what you'll find is you'll give somebody a written reprimand, you'll give somebody a day, you'll not sustain because it's a good guy. And no, you cannot have a critical incident and not have it on the body worn camera. Just have to. So we centralized the discipline so that, because really my end game was not discipline or punishment, it's behavior modification. Because if you're doing the correct thing, you've got nothing to worry about. And so that ties directly into changing the culture of performance.
When you were chief, were you a member of the Police Executive Research Forum?
Yes. Yep.
And are most major city police chiefs members?
Yes.
Okay. We're going to show you Exhibit City 20 on the screen. It's a long document. So I'm going to focus you just on the first page, guiding principles on use of force. Do you see that on your screen?
Yep.
And do you know what this document is?
Yeah, it's a study that PERF put out, and what they do is, PERF is a research forum for the cities, and they do really high level reviews. For instance, that was who I had come into the city to review our chase policy. And so the Police Foundation paid for them to come in and do it. And what you do there, it's independent, but they tend to give really solid feedback, because it's geared towards policing, which is the problem if you just go out and you get Bobby Joe consultants. It's not going to tend to have useful information like you need. So yeah, this was one of their better reports, actually.
And Chief Shields, just so I'm clear, PERF is what you call the Police Executive Research Forum.
I'm sorry, yes.
And can you tell us a little bit about the key terms of the guiding principles as summarized in this document?
What they're showing you is first off, they'll always quote and reference the various different police chiefs to weigh in. And the chiefs are, one of the good things about major city chiefs is they tend to be very open about what's not worked. And so, for instance, this was the first document, I believe it was this one, where I read that New York City and Boston, I mean, there were major cities had not allowed shooting at vehicles for years. I mean, that's like unheard of. And I'm pretty sure it was in this document. But they're all about de-escalation, and they're all about, this report was de-escalation, and also what are you doing tactically to ensure that you are not inadvertently escalating a situation. So it was all about what didn't work and how we have to rethink the teaching the officers to ensure that we get an outcome that is equitable to the infraction that's occurring. And quite frankly, it makes it safer for the officer.
And Chief Shields, I'd see, just as I look at these guiding principles, slowing the situation down. What does that mean in the context of what you've been talking to us about today? So
for years, like if you didn't run headfirst into a conflict, it was really almost synonymous with cowardice. And I can remember having male officers who would not go into a situation, maybe a volatile domestic, until another officer arrived. And I mean, they were just, this is 25 years ago, but they were just creamed for being cowardly. Now what the recognition is, and we're trying to shift the culture to, is to understand, no, the goal is to get out of this safely and not escalate the situation. So if you need to back out and reassess or walk away, depending on what the situation is, and obviously there's some situations you can't walk away from, but it's taking the time to think before you just act. And that's that might sound really basic, but it's not necessarily a given in some of the scenarios that we find ourselves confronted with.
And did you utilize the guiding principles outlined by PERF in your leadership of APD?
I did. In fact, I just referenced them yesterday as well. I mean, this was forward thinking. And I think it's probably going to be, people are going to pay closer attention today than when it came out 4 or 5 years ago.
So, Madam Chair, the city would like to enter Exhibit City 20 into evidence.
Mr. LoRusso?
No objection.
Thank you.
C20 is in the record.
Thank you. Chief Shields, I want to talk about the Atlanta City Code that relates to the hiring and firing authority you had as Chief of Police. We're now going to show you Exhibit City 04, which is the Atlanta City Code Part 2, Chapter 98, Article 2, Division 1, Sections 98-28, hiring and firing authority qualifications of the chief. And I'll note for the board that this has been stipulated into evidence. I want to draw your attention to subsection A, which says that the police chief is the hiring and firing authority for the Department of Police, subject to applicable ordinances, rules, and regulations. Are you familiar with this section of the code?
Correct, yes.
And as a chief, were you the one with authority to make firing decisions for the Atlanta Police Department?
Yes.
Thank you. I'm going to now show you what has been marked as City 03, which is APD SOP 2010, Atlanta Police Department Work Rules, effective January 18th, 2019. We're going to show you Rule 4.2.50 regarding maltreatment or unnecessary force. Madam Chair, this exhibit has also been stipulated into evidence.
Mr. LoRusso, Ms. Lawrence Hardy,
Yes, Your Honor.
do we have a list of stipulations, or I'm
They were
scratching
filed.
my head over stipulated into evidence. Where did this happen?
They were filed with Your Honor.
some time ago,
Okay, but you have no objection. Mr. LoRusso, you're good with this. So when Ms. Lawrence Hardy says it's stipulated into evidence, if you don't say anything, I'll know it's true, right?
That's fine, Your Honor. And if, for the record, they were submitted to you on December 2 of 2020.
Okay,
we
all
can
right, I missed it.
we can resubmit them right now if you like, Madam Chair, so that everyone has them.
That's okay. I just wanted to make sure for the record we were all on the same page. Thank you. Go ahead, please, ma'am.
So turning back to City 03, and looking at the first page of this exhibit on the screen, are you the authority that signed these work rules?
Yes,
And the effective date of these rules is June 18, 2019, is that correct?
yes,
Were these the work rules in effect on May 30th, 2020?
yes,
Are officers of the Atlanta Police Department subject to this rule?
yes,
And can APD officers be terminated for violation of this rule?
yes.
Can you tell me about your experience as chief in determining when officers have used excessive or unreasonable force in violation of this rule?
Other instances of it? Is that what
Well,
we're?
if you could talk to me about your decision-making process, what factors you take into consideration when determining whether this rule has been violated?
So there is the infraction itself, which is right. So there has to be force used. The manner in which the force is used, the circumstances surrounding the force. Was the employee in a position that they had no other alternatives? They were genuinely in fear of their life. Were they getting pummeled by somebody? So you look at the context in which the force was used. You looked at, is the force proportional for the amount of resistance that they're receiving? And what was the totality of the circumstances? So in other words, and this is why the work rule allows, it's a guideline in terms of the discipline, whether it's 20 days suspension, termination, is you are looking at the totality of everything that was occurring. Was this force reasonable and aligned with the training of the Atlanta Police Department?
I'd like to talk specifically about Appellant Streeter and his violation of this rule. He has been referred to as an APD investigator in APD termination documentation, such as the NPAA and the NFAA. Would you explain the rank structure for investigators, senior police officers, and detectives in APD?
Sure. So everyone is hired and comes on once they get sworn in as a police officer. And to go to the next rank, if you're a senior police officer, typically what it means is you're just that. You've been an officer for an extended period of time, and most of our senior patrol officers stay in 911. They'll stay in one of the zones and train the newer officers. That's the norm. People who test, and so there's a test. There's a written and oral exam that officers can take that makes them eligible to be appointed. So it's not civil service protected, such as the sergeant and lieutenant. So it's appointed, but what the testing allows for is a ranking, so that it's just, before there was any sort of testing, the department didn't always have testing. And you would see people sometimes sliding in that maybe you didn't have qualifications, what have you. And the testing just, I think, department-wide came across as a much fairer process. So it's an appointed position, you have the testing, but more than anything, what it is, once you get it, the understanding is that you will conduct yourself in a more experienced manner. And whether you go to, some investigators may want to stay in a zone and investigate burglaries. Some may want homicide for 25 years. But the idea is you should obviously become more proficient in the job. So the younger officer comes to you to say, well, how do I draw up this warrant? What is the correct way to, you know, to make an arrest affidavit? The idea is you are showcasing a greater level of experience and knowledge. When there's a pay adjustment with it proportionately, by the way.
A raise.
Yes.
And would you please describe your expectations of Mr. Streeter in his role as an investigator?
I would expect him to be one of the more senior officers on the street. And especially when are you speaking to the night of the disturbances or just broadly speaking? I mean, let me just say this. If you are an investigator, the idea is you are showcasing the city's standards in the proper way. And yes, you can say that about everyone, but the reality of it is if you have an officer who's only been on the street for 6 months, they are going to have questions. There's no doubt about it. They should be able to look to an investigator and get solid guidance. So with it comes the expectation that you are embracing a greater leadership role.
And Mr. Streeter was also on the fugitive team as of May 30th, 2020. Is that correct?
Yes.
And what does it mean to be on the fugitive team?
The fugitive unit is a coveted assignment. It's been coveted since I've been on the department. And what the guys do and gals is they are responsible for getting the criminals off the streets who have warrants on them. The focus that we put on them is to get the people who are most violent off the street, obviously. So fugitive team will get assigned to them the arrest warrants for murder suspects, aggravated assault, or somebody shot at somebody, a rape suspect, what have you. And they're responsible. Their sole job is to go and find that individual and bring him to jail and bring him into the Fulton County judicial system. So they are truly, that is their singular responsibility.
And so what would be your expectations on May 30th of Mr. Streeter as a member of the fugitive team?
As I said, the fugitive team is a coveted position. It is generally some of our more experienced employees. I expect a high level of performance from them and also a high level of restraint. I mean, if you do warrants all day, or that is your primary responsibility, you're not kicking in a door every time. So to me, those are the individuals that I would expect to really engage in assessing before acting.
I know that Mr. Streeter received training throughout his 17 years. Are those trainings conducted through the Peace Officer Standards and Training Council, otherwise known as the POST Council?
Correct. So yes, so actually, the city of Atlanta employs a bunch of people, but POST is the governing authority for the state. So if the state takes away your certification as a cop, you can't go police, even if Atlanta's hiring you. So you have to meet the training standards set forward by the state, i.e. POST.
I see. I'm going to show you what's been marked as City Exhibit 07, City 07. This is Mr. Streeter's post-council training record, and it has been stipulated into evidence. Can you tell us what a training record shows?
The state tracks all of the training that we receive from the day one that we're hired. So you can go back from the time an officer is employed and literally see every training block of instruction that they've received, and it will list what it was, when it occurred, which is why you want to get training that is recognized by POST. So in other words, if I spend $30 and I go up the street to take a course on DUI testing at my own leisure, the state's not going to recognize that as training they're going to certify. That will not be on your record. That's just your own little thing you're going on the side. state certified training means that they've recognized the course curriculum is meeting their standards. And once you've taken that, it shows up on your training history.
Okay, let's look at Mr. Streeter's recent training histories. I see that he completed, let's look at the 3 most recent trainings here. De-escalation options for gaining compliance, which he had just a few days before May 30th, use of force on May 7th, and cultural awareness on April 22nd. Is that correct?
Right.
And based on your experience and expertise, what would you expect to be the content generally of post-training on de-escalation options for gaining compliance?
So de-escalation is, what are your alternatives to reduce the volatility of an encounter? How can you bring a situation down to the lowest level that provides for the most safety for all involved? So it's instead of, for so many years, what we taught officers was the force curriculum going up. You start with verbal communication, OC spray, nightstick, everything you do to, it really just, it was a one-way street. This is what you do as the force, as you needed more force. Where teachings have gone in the last probably 7 years or so, there's been a much stronger emphasis on, wait a minute, instead of just assuming the force has to go upward in an upward trajectory, how can we reduce it? And so the de-escalation is really putting an emphasis on settling the situation down.
And what about this use of force training? What would you, based on your experience and expertise, expect the content of training to be on use of force?
That emphasis will be largely on when you may use your gun, what conditions and criteria must be met, and this goes back to what's the totality of the circumstances, how do you safely position yourself, should you shoot, should you even take your gun out of your holster. It's the emphasis is really on, the bulk of it is around the firearms instruction.
And does it include tasers as well, or other CEWs?
Not so much. So the taser use, the taser recertification touches on that more so.
And does it cover when one should point one's gun, even if you don't plan to shoot?
Correct, yes.
I want to fast forward to just a little more than a month after Mr. Streeter had these trainings, with, again, the most recent one just a few days before, to the evening of May 30th. I'm sure you remember that evening and that weekend. 5 days after the murder of George Floyd by Minneapolis police, and only 7 days after Mr. Streeter's de-escalation training. I want to just center us all in the midst of the protests in Atlanta related to Mr. Floyd's tragic death. Have you had APD conversations about police brutality specific to the George Floyd murder in your leadership capacity?
Yes, I mean, we immediately knew that was, I mean, I think everybody did. It was so egregious. I shouldn't say every law enforcement. It was such an egregious killing that when the video became public, we knew, you know, I think even, I don't know that I've met a cop who didn't recognize immediately just how abhorrent the encounter was. And so, yeah, it became an immediate subject of conversation, and what the ripple effect across the United States would be, yes.
And were there any specific directives regarding APD's expectation for policing the city on May the 30th, given the protests and everything that was going on?
Right. So one of the strengths, I will absolutely say, of the police department is its management of protests. It is such a part of its history that you find that it's an area that the department historically has been very skilled in. Managing protests is allowing for tolerance. You will see people routinely, if you go back prior to the George Floyd, we really saw a lot of it during Occupy Atlanta. And you know, you let the folks go in the street, get their anger out. I mean, as long as there's not being damage and destructions to building and property, we've always just tried to steer the protests, let them do their marching route. And obviously there's been protests interspersed between the Occupy and George Floyd. And our posture is always that the folks in the turtle suits that look so Star Trek-y like, they'd be out of sight, because just their mere presence is inclined to escalate a situation. And they are absolutely a last resort. And we take a very hands-off, let's just keep it moving approach. I mean, even if you go back to the days of Freaknik, I mean, it's just was kind of, the city just kind of has a vibe of, you know, okay, when we have to take action, we'll take action, get it in and out. But otherwise, let's just work to accommodate this and get people out of here safely. And so that is, and we really, prior to the Super Bowl, prior to the college football championship, so that's going back a few years now, that was when we really wanted to refresh everyone on training them for mass protests, mass incidents, because we knew the spotlight was going to be on the city extensively for those two incidents, especially the Super Bowl. So in fact, I created a division, the Contingency Operations Division, because I was concerned that what I felt was, you can't take police officers and say, oh my God, we're going to have a protest at the end of the week, shove them out there and think that they're going to perform well if they haven't trained on a regular basis. And so Deputy Chief Crair, who's now Chief of MARTA, Scott Crair, he headed up that division. And the singular focus of that division is, I need you every day to make assessments on what is potentially under a threat for the city. Don't think that, Ebenezer doesn't get this stuff. Or when you have a shooting at a synagogue in another city, the ripple effect is here. I mean, and you have a shooting at a Black church in South Carolina, you've got to take care of your churches here. So how are we constantly positioning ourselves to take care of the infrastructure of the city safely, not just covertly, but more so, how are we openly doing it? And how are we going to accommodate the protesters when they come to town? Obviously, President Trump drew quite a bit of interest and protest energy. So how are we going to do it safely? And so the focus of that division is navigating these protests safely. And I would say, by and large, the city had done an exceptional job of it over the years.
And was there a curfew in place on May the 30th?
Yes, there was a curfew. I can't remember if it was 7 o'clock, perhaps. I'm not certain of the time.
I believe it was 9 o'clock. Does that sound right?
It was 9 initially. Yep.
And what was the goal of the curfew?
The goal of the curfew was to discourage folks from just hanging out and to try to, we clearly had individuals who had intentions of wreaking chaos and violence in the city. There's no two ways about it. There was splinter groups that showed up the Friday before Friday, and they were intent on damaging the city, assaulting people. What we wanted to be able to focus on the people who were in Atlanta to wreak havoc. And so what we wanted is and be mindful, this is going on in the middle, as you stated, of the George Floyd protest. So the majority of people are just outraged at George Floyd and police. So they're just protesting. So normally it wouldn't have been such an issue, but a lot of them outsiders, and I always say outside, I mean, they're not our traditional protesters. They're from outlying counties and states within driving distance. what we saw is they were inserting themselves in the middle of this. And they were the ones the night, what we saw the night before is we saw fires, we saw structures being damaged. And what we wanted to do was, okay, law-abiding folks, that you want to protest, we want to accommodate your protests, but we need you to leave now so that we can focus on the folks here who have no intention of protesting, but really are presenting a threat to the safety of the city and the people in the city, just to weed out folks in the crowd.
Was vehicular traffic a target of the curfew?
Well, I mean, I think we would probably be trying to get it on the interstate to get it off the city streets. That's usually what we do when we have congestion like that, is we try to just redirect it and try to get it all on the interstate and coordinate. We always coordinate really well with Georgia State Patrol just to keep it moving.
What role was Mr. Streeter tasked with that evening?
So he was on most of our folks, the majority of them were at the street level. And whether they were part of the process of just, ensuring that the protesters were doing just that, just protesting, and that people were not damaging buildings, starting fires, looting. And also then when the curfew started, we would start telling people, go home, go home. We were just trying to keep order.
And what were you doing that evening while all of this was going on in the city? Do you remember?
I spent, for me, I alternated between riding around. I would go to the command center, I'd ride around. I think, I don't know if that was the night that I went over to the state headquarters at one point. So I was just moving about.
We're going to show you some video footage from May 30th. As I know that you have already seen, we went to give the board an opportunity to see. Just to ensure that we have the necessary authentication, let me just ask first, did you watch on May 31st, 2020, body-worn camera footage that was recorded the evening of May 30th, 2020?
I did, yes.
Okay. At this time, I'd like to show you exhibits marked City 10 through City 15, which are exhibits from 6 different body-worn cameras for APD officers on May the 30th, 2020. In the interest of time, I'd like to play them one after the other. They are from different officers at the scene and the same time, so there's some overlapping footage from different angles. And I know, in fact, that you saw different footage from different angles during your investigation. Madam Chair, so that you and the board know, it will take approximately 15 minutes to play these 6 videos.
Well, then hang on just a minute. Does anybody need to take a break? Because I'd rather see this all the way through. Everybody's good? Okay, hearing nothing, here we go.
Let me ask.
Yes.
Can we identify ahead of time where Officer Streeter is in this video? I mean, I would like to know ahead of time rather than after going 15 minutes of looking at it and then finding out where he is.
With your permission, I can each time let you know whose body cam footage we're viewing. Would that be helpful, so that you know, and you'll be able to see from Officer Streeter's body cam which one he is?
But on the other officers' body cams, I think we're going to have difficulty identifying Officer Streeter, right?
So the best place to see Officer Streeter's conduct is on his body cam.
Okay.
Mr. Streeter's body cam video will give you the clearest view as to his. I am happy to, as you can imagine, we've watched it many, many, many times. So I'm happy to narrate and give additional information there, and Chief Shields can do so as well, perhaps from the witness stand. But the most accurate view I think that you'll find is from Appellant Streeter's camera itself. I think the real question then becomes whether is looking to the other videos to provide the bigger context.
Okay, we'll see. Okay, fine.
Okay, Ms. Lawrence Hardy, one question here.
Yeah.
Are we to assume that Officer Streeter is in every one of these videos?
The reason that I'm pausing is because some of the footage is on the right side of the car. Right, so there was an interaction. There are two, as you know, we will be together again this month. There were two people in the car, two students in the car, one on the left and one on the right. And Officer Streeter is back and forth. And in fact, it is. I'm not, you will, to get the full picture, you'll need to see all the videos, but I'm not certain if you may hear him sometime rather than see him, etc. Again, you'll see when he pulls his weapon, for example, you'll be very clear on it being Officer Streeter's body. That it being his body cam video that's being used. It would be, may I say this? If I could show you the video, I think that it will give you the full picture. I think it's hard to do it in isolation and to know it without seeing it all. I also do want to point out that we have demonstrative versions of it as well in slow motion that make it easier to identify where Mr. Streeter is in each of the videos. We want to be very respectful of your time. And so we had not planned on showing the slow motion ones, but we do have those available and are happy to go through if there's any point in the video where you're interested in, or you're not clear whether that's him or someone else. But I think you'll find it pretty clear which one he is.
Go ahead, ma'am.
Right, we will go ahead and put it up. And if I may suggest, if you have trouble with it pausing, what we have found with video is that if you turn off your own video, it can sometimes free up bandwidth so that you can observe the video more easily.
He's getting in the car. He's getting in the car. He's with us getting in the car. If you don't go, man, you don't go to jail. If you don't go, you don't go to jail. If you don't go, you don't go to jail. Stop! I'm getting out!
All right, we're going to pause there for a moment. So this video that you've just watched is the body cam footage from Lonnie Hood, from Mr. Lonnie Hood. And again, you
Was that number 10, 11, 12, 13, 14, or 15?
Yep, so that is exhibit 10. City
Okay.
10 is a video expert, and if you have the list handy of our exhibits, you'll see that his body cam is referenced, his number for Lonnie Hood up in that right-hand corner.
Thank you.
And so, as I said, you have Officer Streeter on the left-hand side, and he is the one who takes Mr. Young out of the car. And then you have Officer Gardner, who's not part of this, will have his own hearing on the right-hand side. And we will be together to discuss his situation with Ms. Pilgrim. And so we show the full video because from an evidentiary standpoint, Chief Shields saw the entire video, and that's why we want to make sure you have the information. And we did not think it was appropriate for us to slice it up in various ways to make sure that you had a full and complete picture. But again, we do have a slow motion version, which we are happy to show. The next video that you will see is from Officer Streeter himself. So that comes from Mr. Streeter's body cam. You'll see the last 4 digits of his body cam are A5R7, and you'll see that in the upper right-hand corner. And you'll see, for example, when there's a hand out in front of him with the gun pulled, that is Mr. Streeter's hand pulling the gun on the students.
That gas ain't just doing up and pushing my way. You gotta start hitting them.
Hey, we're good. We went today. The group walked away. That's the charge. Yeah, that's fine.
You want to go?
No, please, 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 no! 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 No, please, no! No, please, no, please! I'm not doing it!
Back in the car. Hey, you about to go to jail? Where you gonna go? Where you gonna go?
I'm not about to.
Where you gonna go? Just drive on.
No, come on, man. It's like, let him go. Let him go. Let him go. Go, man. No, please. No. I can do anything. No, please. No, please, sir.
Gunfire? You real shots, ain't you?
Shots fired. 1.5 out.
He can't go nowhere. He can't go nowhere. He can't go nowhere. Hey, give me an hand. Give me an hand. Hit the window. Open the window. Open the window. Stop the car. Put the car apart. Put the car apart. Put the car apart. Put it in park. Put the car apart. Hit the unlock. Hit the unlock. Hit the unlock. Hit the unlock. Put him down, man. Put him down. Put him down. Hey, right there, right there, right there. Zip him up and move him back. Let's go. What are y'all doing? What happened? What was that from?
That kid was telling him to keep going. He had a juke over the curb. One dude and he wouldn't drive off.
We will next have the footage from Willie Sauls. You'll see the body cam identified last 4 digits of B3JB. Thank you. And in that video, and to respond to the questions of Board Member Elamine and Board Member Fall, the easiest way to follow which person is Mr. Streeter is he is the one who pulls the gun from his holster and points it at Mr. Young. We'll next see video footage from Sheldon Drinkard. The last 4 digits of his body cam are B17E.
When do we put in that?
That's Lucky, where's he at?
It's copy 67, radio,
We're across from the American in the park. All right, everybody is good here now. From now on, we're not going to be able to locate him right now. Just keep an eye out.
Can we lift the 67? 337 lifted to 146. We have 1415.
Yeah, we're currently international. Right in America, we take it that way, but it is a large group of people in the street, so we're just trying to get to it.
3C, Rogers in the street.
You have eyes on the shoe color? You have eyes on the shoe color? That shooter was over here, 150, 15, 12. We had that set up. The 4001, the unit 15.
Next, we have the video from McKaysey, Stephen McKaysey, last 4 digits B8RH.
Southbound 10, turn it black, no all black.
What's that?
Southbound on Ted Turner. You still have a visual? Where's Lieutenant Knapp?
That's Lucky. Where's he at?
Copy 6-7,
We're across from the American in the park. All right, everybody is good here now. There's a male and all flashing, but I'm not able to look at it right now. Keep an eye out.
Black and all black. Possibly American in the park. Can we lift the 6-7?
Okay.
And then finally, we have footage from the body cam of Carlos Smith, last 4 digits AAJ9.
Southbound 10 Turner, black and all black.
Where's he at?
Wait, what's going on? I'm not even outside. Wait, what happened? What happened? Watch your back.
Everybody is good here now.
You got a gun. Watch your hand. Right there.
Thank you. And again, members of the board, we are happy to show you any of that footage that you'd like to see again, or if you'd like to see Mr. Streeter's footage exclusively. We thought it was important that you saw all of it so that you could get the full picture. It's difficult to really understand what was happening on the driver's side of the car without seeing what happened on the passenger side at the same time. So we wanted to give you the full picture. Chief Shields, our exhibits City 10 through City 15, which we have just viewed, fair and accurate portrayals of portions of the May 30th, 2020 body cam footage that you watched on May 31st, 2020?
Yes.
And those body cam excerpts have been stipulated into evidence. Chief Shields, did you observe Mr. Streeter on the body cam footage we just watched?
Yes.
Did you see Mr. Streeter pointing his service weapon at the driver of the vehicle, Mr. Young?
Yes.
Did you see the driver of the vehicle, Mr. Young, filming with his mobile phone at the beginning of the incident?
Yes.
At this time, what was APD policy related to citizens filming police?
We allow it. It's the city lost a lawsuit years ago that stemmed about officers arresting someone who was trying to film them making an arrest. So it's been codified in policy for years that citizens are lawfully allowed to film us when we're doing the job, provided they're not interfering with us doing the job.
Did you review the footage before you made any decision on discipline for Mr. Streeter?
Yes.
For how many hours did you watch body cam footage before making the decision?
I would say at least 4.
Did you have an opinion at that time on Mr. Streeter's use of force towards the young man, we now know as Mr. Messiah Young, given Mr. Streeter's recent trainings on de-escalation and use of force?
I was really discouraged when I saw the video initially the night before. we had been told, we actually found out about this incident from the media. Someone had filmed it. And the officers on scene communicated to their supervisor that this had all occurred because there was a gun. And so I was, all right, well, if the driver was pointing a gun at them, certainly. As we drilled down on this, a gun never materialized. And I think the general consensus is there never was a gun. And it was just really, you know, we're having mass civil unrest across the United States as a result of police brutality. We had the Friday night was absolutely, it was civil unrest and civil disturbance at a level that I don't think many of us had ever seen in Atlanta, thankfully. So we're going into Saturday, and with the assistance of the National Guard and just the presence of people, we're trying to keep a lid on this powder keg. And I remember thinking that, okay, it's not easy, but things are definitely going significantly better Saturday night than Friday night. So then to see the video, and you're looking at two kids who are probably just out doing just exactly what you said, filming, and they're stuck in traffic. They can't go anywhere, and they're getting mixed messages on what to do. And we completely escalate this situation for what? And the car was left out in the street. The people weren't processed. The arrest tickets weren't given on them properly. You're terrifying two people that are sitting in a car. I mean, it's like, come on. What we're supposed to be de-escalating this stuff. They're protesting police excessive force, and this is our response. And it really ticked me off, quite frankly.
Did you ever see any evidence that Mr. Young had a gun? I know you said it never materialized.
No.
Did you hear the officer yell, "He's got a gun," in the video we watched?
What eventually occurred was there is one little snippet late into the interaction where an officer says gun, but the actual gun that's in the car is another officer's gun.
And when did you hear that in relation to when Mr. Streeter pointed his service weapon at Mr. Young?
It was well after that.
When did you hear that statement in relation to when Mr. Young was being tased by Mr. Streeter?
It was after that.
Did you hear conflicting demands from the various officers at the scene? You talked about the mixed messages.
Yes, I mean, that was one of the obvious takeaways is we're telling them to leave, we're telling them to stay. They're getting yelled at from multiple directions. What are we telling them to do? And I think that is relevant. It goes into, again, what are we doing to the situation? Are we settling the situation down by our presence, or are we actually exacerbating it?
How should a reasonable officer have handled Mr. Young?
What I would expect from, and I think most of your more, well, I want to say seasoned, experienced officers, but these folks were, is, I mean, honestly, you could go up to his door, knock on the door, tell him to put the window down, tell him what you want. I mean, talk to him. And it's just like, why don't we just ever just talk to people? Tell them, where are you going? What are you doing? All right, well, you need to get out of here once you can. I mean, obviously you can't right now because there's traffic, as they alluded to. I mean, I don't know. Just talk to him.
What did you conclude about Mr. Streeter's performance after reviewing the body cam footage from May 30th?
I thought that it was excessive given the amount of resistance that he was not presented with. I thought, in light of the fact that we were in the middle of mass civil disturbance trying to quell violence, trying to keep the city from having further fires. As a result, on the heels of police brutality in Minnesota, it just was completely disproportionate and ran afoul of everything that the police department was attempting to accomplish.
Did you determine that Mr. Streeter's conduct violated APD Work Rule 4.2.50 regarding excessive force?
I did.
And did you decide to dismiss Mr. Streeter for his violation of Work Rule 4.2.5.0?
I did.
We will now show you the exhibit marked City 16. This is the warrant for Mr. Streeter's arrest. Did you receive a copy of this document?
Your Honor, I object to this. This took place well after the termination, so this obviously could not be a basis for his termination.
Your Honor,
Ms. Lawrence Hardy?
We would certainly explain. First, let me just say that all we're doing now is laying the foundation so that we can get it admitted into evidence. We can then have determinations about what purpose it's serving. But certainly it is a business record and hearsay rules don't apply. And so I believe that Chief Shields will shortly testify that she received a copy of it. And I know that Mr. LoRusso has said that he believes she received it sometime later. He can certainly cover that in his cross-examination of Chief Shields.
And so it's relevant to what?
Once we have an opportunity to talk with Chief Shields, she will tell us when she did or did not receive the document. And again, Mr. LoRusso may want to further inquire on cross-examination.
Okay, so this document isn't relevant to the matter before the Civil Service Board, which happens to be the employment action. So I'm not going to allow it. What's your next exhibit?
I should have some additional questions for Chief Shields before I get to my next exhibit. And I just
okay, and ma'am, I just want to point out to you that you are an hour and 12 minutes into your time, not including the breaks or, excluding a couple of 5-minute breaks. So
thank you, Madam Chair. I only have this one witness and I'm about finished. So we'll just plow on through.
Thank you, ma'am.
Turning to the dismissal, Chief Shields, I'm going to show you City Exhibit City 05. This is from the Atlanta Municipal Code. And if you look at the second sentence, it says, when an infraction is such as to impair or destroy the future effective performance of the employee, or when the employee's presence impairs the effectiveness of others or presents danger to the employee, others, or city property, action shall be taken to immediately remove the employee from the work environment. And this has been stipulated into evidence, this exhibit. Did Mr. Streeter's conduct affect the public standing of the APD?
Yes.
Did his conduct erode the public's trust in the APD?
Yes.
Could his continued employment have impaired the APD's effectiveness in working with the public?
Yes.
And now I'm going to show you City Exhibit City 06, Part 2, Chapter 114, Article 6, Division 3 of the Atlanta Municipal Code, where it says, an employee against whom an adverse action is to be taken shall be given a written notice of the proposed adverse action signed by the appointing authority or designee at least 10 working days prior to the effective date of the proposed adverse action. However, in an emergency situation, the adverse action may become effective immediately following the employee's response, if any. Do you see that?
Yes.
And were you aware of this provision on May the 31st?
Yes.
Is the NPAA notice marked as an emergency action?
It should be.
What was the reason that you needed to act decisively in this particular case?
Oh, because what we knew was that this video was providing an enormous amount of fuel to the anger that was already simmering out there. And if we didn't show that we were going to take that seriously before dusk, we risked having another powder keg of an evening like we'd experienced on Friday night. There was a real risk to public safety.
And just looking here at the screen at the MPAA, that's where it was marked emergency action.
Correct.
What did you weigh in determining not to wait longer before dismissing Mr. Streeter's employment with the APD?
Well, as I stated, we didn't have the luxury of time because of the volatile nature of the environment that we were operating in. I would have, under different circumstances, I would have still come to the same conclusion, but I would have liked to have had time to just slow it down. But the reality of it is there was a very real risk. I mean, this video inflamed everything to levels that we had finally quelled out that level of anger, and it just served to inflame things. And to get before a microphone and say, well, we're looking at it, and a week later fire them, yeah, that would have felt more comfortable from an employment standpoint, but we just didn't have the luxury of time then. But we just didn't. But the end game would have been the same, so we had to do it then.
Does the notice provide Mr. Streeter with the time to respond?
Yes, it said 6 o'clock.
And did he respond?
He did.
How did he respond?
So he was in the lobby, and I went out there. He was out there with Investigator Gardner, and went out to them. I was like, okay, guys, let's go either together, one-on-one, to meet with them, to talk to them, because I wanted to have a face-to-face with them. And they both said that they were waiting on a union rep. And I said, guys, I'm sorry, I don't have the luxury of time. If we're going to talk, we need to talk now. And the union person wasn't going to be there for, I think it was like 20 or 30 minutes. And I just said, guys, I don't have that time. And I just got a blank look back. I said, all right, well, in that case, I'm going to need to tell you that you're being terminated, and I'm sorry. So they did respond, that because sometimes you have people that just do not show up at all. But they did come, but the union rep wasn't there.
Would discussion of Mr. Streeter's dismissal with him or his representative have affected your decision to dismiss him from the APD?
No.
Based on speculation.
Based on your experience and expertise as the chief of police, former chief of police of the APD, do you believe discussion of Mr. Streeter's dismissal with him or his representative would have affected your decision to dismiss him from the APD?
No.
I want to show you what was marked as City 02. This is the notice of final adverse action that's been stipulated into evidence. What is the final action imposed?
It's dismissal.
And what is the effective date?
June 1.
Did you deliver the NFAA to Mr. Streeter?
Yes.
And that was just after 6 p.m. on May 31st?
Yes.
Thank you, Chief Shields. I tender the witness.
Okay, before Mr. LoRusso, we go on to cross, let's take a 10-minute break. And I'll see y'all back here at 12:14, according to my clock. I'm here. My apologies. Mr. LoRusso, you ready?
I am, Your Honor.
Okay, proceed. Well, wait a minute. Hang on just a minute. Whoops, sorry. Ms. Lawrence Hardy, let's go backwards. Did you move to introduce, or were C1 and C2 part of the stipulated?
You know what, Madam Chair, just to be clear for the record, I'd like to at this time move to admit all of the exhibits that I presented to Chief Shields.
Okay, Mr. LoRusso, any objections?
No objection, Your Honor. As a matter of fact, that they were stipulated to. We have them down as A18, but they were stipulated to.
Okay, thank you. Just
I
wanted
just
to
want
get
to be
that.
clear. My motion is for all of them, not just the particular ones Mr. LoRusso just referenced.
Well, for the exception, wait a minute, for the exception of C16.
With the exception of C16, which the chair declined to admit.
Mr. LoRusso, you good?
You're on mute, Mr. LoRusso.
I was under the impression we made a timely objection, so yes, that would exclude that.
Okay, all right, go ahead, sir.
Chief, how are you? I was going to say good morning, but apparently we're in the afternoon.
Thank you. Good afternoon.
I'm going to show you an exhibit. It's City Ordinance 114-532. Now, as a chief of police, you've familiarized yourself with these ordinances that relate to personnel matters?
Yes.
And if you look at Section B, it governs an emergency action. And if there is an emergency action, you're supposed to give 5 working days of the effective date for the time between the notice of proposed action and the notice of final action, correct?
That's one component of it, but I know the law department has weighed in previously, and that taken in its entirety, you can do an emergency action immediately.
That's not written in here. That's somebody's opinion in the law department. Is that what you're saying?
Yes.
Okay, well, let's go with the black letter of the ordinances that these officers have an opportunity to read when they're on the street. How about the notice of emergency action shall include a statement of the emergency situation that caused the action to be taken? Did I read that accurately?
Yes.
Nobody's abrogated that by opinion, right?
Correct.
So if we look at the notice of proposed action and the notice of final action, that's not on there, is it? There's no statement as to why this is an emergency action.
Mr. LoRusso, is there a document you'd like her to look at when you said, when you look?
The notice of proposed administrative action or adverse action and the notice of final adverse action. Do you have those with you or do I need to put them back up?
I've seen them and I know that the.
Kim, can you put up the notice of proposed adverse action? They're already admitted into evidence. There's no statement there consistent with 114.532, the statement of why the emergency action that caused the emergency situation that caused the action to be taken, is there?
There's not a statement, no.
Matter of fact, there's a plethora of blank space, a lot of real estate there in the middle for you to have written that, right?
I know, because we never write that there. It's only the disciplinary action.
Because you said this was an emergency action, correct? And at the top right, it has emergency action check.
There's a typo on it, but on the NPAA, which was served to him, it's filled out correctly.
Okay, I was actually speaking of the NPAA. It says emergency action, correct?
The other document says an emergency action, yes.
Okay, so let's go to the final that's in front of you now.
Yep.
And there's no statement there of what the emergency situation is. You said you never do that, right?
Correct.
But
Not
you also not
on that form. The subsequent form that's attached to this states what the infraction is.
There's no statement of why this is an emergency situation, is there, anywhere in this documentation?
Oh, I disagree. I think that the charge is listed on the use of force.
Now, Chief, I'm going to be very, very particular with you, and we are under a very tight time constraint. 114.532 says a statement of the emergency situation, why this situation justifies a deviation from the normal procedures. There's nothing that says, as you said, in this environment, we didn't have time to wait. There was unrest in the city. If we didn't fire them, we were going to have more problems. I couldn't go to the lectern and say that we were going to wait. None of that's in there, right?
Objection. That is most certainly a compound question, and I'm not sure what the question is, Mr. LoRusso.
Well, let's see if the witness understands it.
Wrote out the charge, what the use of force charge was. What I would submit to you is, even if it wasn't an emergency action, it met the criteria for termination.
And in the upper right where it says emergency action, you checked no, correct?
There's clearly a typo there, correct.
And in the summary of employee response, you didn't write anything in there, right?
Can we go down?
It would be up. It's being highlighted right now.
Thank you. Correct, there's nothing there.
It doesn't say refused to give a statement, does it?
It doesn't say anything.
It doesn't document anything about that. And this is a termination, correct?
Correct.
And then when we go down to the witness signature at the bottom, Kim will move that up and highlight it for you. At the bottom of the first page, it says witness signature under your signature. That's blank too, isn't it?
Correct, yes.
Now, you're familiar with the disciplinary process. It is the policy, the SOP on disciplinary process 2020. It's stipulated to. You're familiar with that policy?
Yes.
And that policy mandates with any termination, you're supposed to tape record any statement and interaction with an employee, right?
During the hearing, yes.
But you didn't have time for that?
We didn't have the hearing because the union rep wasn't there.
And you didn't have 20 to 30 minutes to wait. Was there going to be more unrest in the city in that 20 to 30 minutes?
Could have been, I don't know. I don't know.
But at the time, it was still supposed to be under investigation, so nobody really knew what was going on outside of the city, outside of your office, that these officers were in there talking to you, right?
Objection.
Ms. LoRusso?
I'll rephrase it. I don't think the witness understood my question. When you state that you didn't have 20 to 30 minutes, the only people who knew, according to your testimony, that they were in your office were you, Streeter, and Gardner, right?
Objection. That states facts, not in evidence. She did not testify to that. It misstates facts.
LoRusso, I agree with the city on that.
You were considering this action, and you were there with Streeter and Gardner when this supposed opportunity came for them to give a response, correct?
Yes.
And in that regard, nothing prevented you from tape recording your opportunity that you gave to them to make a statement, right?
If they were going to make a statement, we would have recorded it, yes.
My question is a little different. Nothing prevented you from recording that interaction where you asked them if they wanted to give a statement, correct?
I'm going to object to the relevance here. The code doesn't.
I'll allow it. I'll allow it. Witness will answer. Go ahead.
Nothing prevented you from documenting recording the interaction where you asked and gave them an opportunity to make a statement, correct?
I didn't record it, but I was standing there with the city attorney, so it wasn't just myself that heard it.
My question is, Chief,
Yep.
nothing prevented you from recording the interaction when you say you gave an opportunity to Investigator Gardner and Investigator Streeter to give a response to the notice of proposed action.
Correct.
And the purpose of the delay between the notice of proposed action and the notice of final action is to give the employee not only a time to respond, but the time to review the file and get information and prepare for that meeting, correct?
Ideally, yes.
Well, ideally, that's part of their due process right, correct?
When it's not an emergency situation, typically, yes.
Well, it's an emergency situation and non-emergency situation. So let's go back to if it was not an emergency situation, they would have time to prepare a statement, sit down, read any documents against them before they made a statement. So it would be a meaningful opportunity for them to provide information to you, correct?
Objection to form.
Hang on just a minute. I understood the question. Go ahead, Mr. LoRusso.
Can you answer the question, Chief?
Typically, they would have an opportunity to prepare and respond.
Investigator Streeter did not have that opportunity, did he?
He did not.
And when he was called to your office, he didn't hesitate. He came right to your office because you asked him to, right?
He came, correct?
And if we look at this case, would you agree this is a priority 1 complaint as described in the disciplinary process where there was official acts of a serious nature or an allegation of excessive force?
Yes.
And your policy specifically states that OPS will investigate those types of complaints that are priority 1, correct?
Yes.
That didn't happen here, did it?
Well, I mean, it didn't take the traditional form. No, I'll say that. It didn't go sit over in their office for a period of time, but there was an investigation that was done.
By you?
By myself, my colleagues, and we did not have the luxury of time, and on emergency hearings, you don't always.
In an allegation of excessive force, you worked in internal affairs.
Mm-hmm.
Internal Affairs, OPS, will interview the officers, correct?
Yes,
So one of the allegations and concerns you had that you were asked about on direct was the fact that Investigator Streeter drew his firearm, correct?
yes,
And you never asked him why he did that, did you?
did not,
You never asked him why he deployed his taser, did you?
did not,
Never asked him why the individuals were stopped in the middle of the roadway and why they were not permitted to leave and placed under arrest, did you?
did not,
In fact, you didn't ask him anything, did you?
did not.
In fact, nobody asked the officers who were on the scene prior to you terminating Investigator Streeter why they took the action they took.
That's not correct. Their supervisors spoke with them. So there was definitely communication, and the answers we got changed over time. So they were definitely spoken to by their supervisory staff.
Well, we'll talk to Captain Shearbaum later. Your conductive energy weapon, the city wouldn't stipulate to it. You would agree that that's relevant to this case, do you not?
Let me just, again, Mr. LoRusso, I don't know if you mean legally relevant. Chief Shields is not a lawyer. She can certainly testify as to her understanding.
What
Would
was
you
the
agree?
question? What was the question?
I asked if the former chief of police thought the conductive energy weapon policy was relevant to a case where she fired an officer for using a conducted energy weapon. That doesn't require a legal analysis.
Objection to form, but she can certainly answer it.
Well, thank you, ma'am. I think he can. I think she can too. Go ahead, Ms. LaRusso.
Can you pull up that policy, please? The conductive energy weapon policy at 3.7 states specifically, OPS shall investigate suspected employee work rule violations arising out of an employee use of a CEW in accordance with the disciplinary process policy, correct?
Yes.
But that wasn't done.
No.
And in fact, every one of your supervisors has an obligation to refer any allegations or things that they see that may be excessive force to OPS, correct?
Well, back up. They didn't notify the supervisor that they pulled out their tasers. That was part of the problem.
As opposed to speaking with their supervisors that you just discussed a moment ago?
They did not. The supervisors found it out by watching, by the news media. We all did.
And they wrote police reports, correct?
Once we told them to, and they went, and that was a fight to get the reports as well. They were asked for them Saturday evening and told not to go home by Chief Gibbs until they'd done the reports, and they went home. Some of them did. And she had to track them down Sunday morning to get the reports done.
Chief, you know how many hours they worked that night?
I believe me, we all were working, but I also will tell you that when you take action like that, before you even go home, you've got CNN calling, you have to stay and you have to finish the job.
Objection, non-responsive. Do you know how many hours they worked that night?
How many?
I asked you, do you know or not?
Oh, I don't know. No.
Do you know what a 6-7 is, Chief?
What's a 6-7?
A code 6-7 on the Atlanta radio? That doesn't ring a bell to you?
Be quiet.
And what does it mean when it's transmitted over a radio?
Be quiet. Stay off the radio.
Stay off the radio. Why, Chief? Explain to this board why an officer would put out a 6-7.
Well, for any number of reasons. They might be going into a home where they think there's a burglar. So you're trying to go somewhere. If you think that basically you want the radio free of traffic, car chases. If there's a car chase, you may ask others, tell others to have there's dispatch may tell others to have a 6-7 so the people pursuing the car can have the radio time. You're basically asking for non-essential radio traffic to be held so that the frequency can be reserved for your
Thanks for the examples, Chief. But the reason for a 6-7 is because, according to your policies, the radio station needs to be quiet because what's going on, those officers may have to transmit could be extremely dangerous, serious, or life-threatening, correct?
I mean, yes.
Now, you made a discussion of the PERF rules and the PERF recommendations, right?
On their use of force report, yes.
And you made sure afterwards that your City of Atlanta policies met with the guidelines of PERF?
No, I never went back and aligned our policy with the PERF report.
But it was 4 years ago, correct?
It was 4 or 5 years ago.
And then the incident here took place some 8 months ago.
Correct.
Now, you also said that you reviewed the body cameras, and you said important to know was the totality of the circumstances. The body camera doesn't tell you the totality of the circumstances, does it?
Oh, I think it does. I think it captures quite a bit.
Really? Does a body camera tell you whether an officer is in fear of their life or not?
Well, I mean, point taken.
Does the body camera tell you what the infraction was if it doesn't show up on the body camera? Don't you have to ask the officer what it was so you can judge their conduct?
Well, you can read the report.
One of the other things that's in the disciplinary policy that's been stipulated, at the conclusion of the employee's response, you're supposed to ask for an alternative punishment and a recommendation from the employee, right?
That's if you actually have what's typically the recorded hearing, yes.
Did you look at these two investigators and say, I'm fixing to terminate you. Do you have something else you want to propose?
Oh, no, they weren't. I wasn't going to start a formal dialogue with them. Once they said that they did not want to speak without their union rep, it would have been inappropriate for me to start negotiating.
But their policy allows them to wait until a union rep gets there, right?
I'm sure. I don't, if you're called down, yes and no, not necessarily. When you're called to OPS and you have a 30-minute window, if they give you a 30-minute window, you have to be there. So for a disciplinary file, and if your union rep can't make it, they do have the right to move forward with it. We certainly try to accommodate the employee where feasible.
Not yet, just get it ready. But again, you didn't have that 20 minutes to wait, right?
Correct.
And Investigator Streeter gave 17 years to the city, so you couldn't wait 1 minute for every year that he gave?
I guess not, no.
I'm going to show you what an email that you sent out. It's our Exhibit 35. We weren't able to get a stipulation on it. Now, let me ask you while that's pulling up, do you recall making a statement, I can't say enough about the department's homicide and fugitive units. These units embodied professionalism, teamwork, and just gritty guts. You remember saying that about your fugitive unit?
Yeah, I love the department.
Now this exhibit's up, and if you look, you described, well, let's just put this in context. This is June 2nd, 2020. You put this email out to the entire department because of the unrest within your department following the termination of these two officers, correct?
No, let me say this. When I did things, this is not the first time I ever sent out a department-wide email. When I would do something that was an aberration from what the culture has historically been or deviated from what officers were comfortable with, it was imperative, I believe strongly in communication, because I think when people have the information and they have an understanding why the decision was made, it puts them in a much better space to process it and move on. So this is not the first time I've done that.
Okay, so you're trying to inform them of what was going on. Like you say, the situation was highly dangerous and unpredictable, correct?
In my email, I'd have to reread it. I'm trying to read it.
Go ahead.
Okay, I read that paragraph, yep.
You called the situation highly dangerous and unpredictable, correct?
Yep.
Sounds a lot like Graham versus Connor, unpredictable, rapidly changing environment.
Absolutely.
And you said we gave conflicting instructions, yet Messiah Young was told to leave some 10 times, wasn't he?
I didn't hear it 10 times. And I also, I heard him being told to get out of the car, told to leave. It went back and forth.
When you wrote in here, this is basically on the June 2nd, I'm very concerned with the space we find ourselves in, both tactically and emotionally. Multiple agencies were assisting us in managing this incredibly volatile time, have pulled out effectively immediately. They are not comfortable with their employees being leveraged politically by the potential of also facing criminal charges. Did I read that accurately?
Oh, yes.
And the short uptake of that is, Chief Shields, after you terminated Ivory Streeter, every metropolitan agency, except for the State Patrol and the National Guard and other state agencies, refused to help you, even though you called and asked them personally.
No, that's incorrect. They pulled out when Paul Howard moved forward to indict all of them. That is when people pulled out. And I received calls from them apologizing why they were pulling out.
And I would just like to make an objection here, Madam Chair. When I showed the arrest record, Mr. LoRusso objected and said it was irrelevant. Now he is going far beyond the date of May the 30th when the decision was made, and I would think that the same ruling would apply to this line of questioning.
Ma'am, you tried to show the arrest warrant, not the criminal record, number one. Number two, I'm going to allow it. Go ahead, Mr. LoRusso.
The long and short of it is, Chief, and it was all over the media, that on June 1st, not June 2nd, on June 1st, multiple agencies pulled out. Essentially, the police chiefs and sheriffs in the metropolitan community passed judgment on your actions and you failed. Isn't that true by your peers?
No, it just doesn't fit it doesn't fit. No, it was the arrest warrants, because think about this. Think about it practically. I can't fire their employees. They weren't intimidated by my actions. What bothered them was when they saw Paul Howard, who was also their district attorney, could indict their employees, they said, time out, we got to get out of here. It wasn't an employment issue. It was truly whether their employees were going to be criminally charged by the same DA that our officers were being indicted by.
I don't have any other questions. I would ask that she be reserved, though, in case there's any rebuttal that has to be done, if the city has time for that.
Does the city have any redirect?
We do, Madam Chair, just briefly. Chief, there were several officers involved in the incident of May the 30th. Is that right?
Correct.
But not all of them were terminated on May 30th, May 31st, after you watched the footage. Why did you treat Mr. Streeter's dismissal from APD with more immediacy?
Streeter and Gardner were the most visible and immediately the ones that we immediately recognized that, okay, this is a clear infraction. Who are these two officers? What are they doing? And, you know, I will readily say, I wish we'd had the luxury of more time, but we didn't. And those two officers were the ones that immediately jumped out as having violated protocol and training.
Are you aware of anything that required you to record Mr. Streeter when you talked to him in the hallway around 6 p.m. on May 30th about whether he was going to make a formal statement?
No, I mean, I would feel like that to me would be really inappropriate. It was a conversation, and to me, that would be really underhanded, quite honestly.
Are you aware of anything in the city code that requires an OPS investigation in every disciplinary case?
No, and in fact, depending on who the person is, if we don't want it done in-house, we'll ask the law department to do it.
And in emergency situations under the city code, are all internal APD policies followed as in standard discipline cases?
Yes.
In emergency situations, are there sometimes changes because of the emergency nature?
Yes.
But the city code is still followed, correct?
Code is still the same, yes.
And did you determine that the termination of Officer Streeter was an emergency situation?
It was deemed an emergency situation, yes.
And on what date did you deem it as such in your professional judgment?
The Sunday, that Sunday.
May 31st?
Yes, I'm sorry, yes.
And thank you, no further questions.
Mr. LoRusso, anything further?
Very briefly, when you talk about OPS, they don't investigate every infraction, but there's 3 or 4 spots in your policies: a conductive energy weapon policy, the use of force policy, the disciplinary policy. When it has to do with a priority 1 complaint involving excessive force, OPS shall investigate. Isn't that what the policy says?
Policy does say that, yes.
And when you keep talking about the luxury of time, I didn't even count how many times you said it. You talk about the luxury of time and the environment. Basically, you're talking about political pressure. Isn't that true, Chief?
No, I wish it was that simple. Those 2 nights had been really like nothing I don't think any of us had ever seen. I hear what you're saying. Yes, there's definitely times where stuff is political, but this was a different breed. This was a different animal. This was a safety issue.
I don't have any further questions, but I would ask that she be held in case she has to, if there's any rebuttal.
Judge, could I get a couple of points of clarity with Chief, please?
Go ahead.
Chief, this is Cleveland Alameen. Couple of things, and this is the first time I'm hearing any of the cases, so I'm only dealing with Investigator Streeter's case. But who broke the window of the car?
Well, initially, Investigator Sauls was hitting on it with his nightstick, but he couldn't get it to break. And I've got to go back and look who came up and actually had a tool to, I have it in my notes.
Okay, so it wasn't Officer Streeter though?
No.
It sounds like somebody is saying a couple of things I'm trying to get clarity on. It sounds like someone is saying break the window. Is that Officer Streeter saying that or not?
I don't know.
Okay, then, but it does sound like it's Officer Streeter asking the person on the other side to push the unlock button. That's his voice there, asking him to push the unlock button so he can open the door on the driver's side. Is that correct?
You know what? I think we would need to ask him that, sir.
Okay. So the only other thing I had is, and this just so I'll understand, in the training for tasers, is there some information given to how the person who is tased, what state of mind, what state of mind are they in when they get tased?
Yes, and in fact, what we do is we ask everyone, all of our recruits and officers who are issued tasers, to voluntarily get tased. And I myself did that so that, because I think it's important that you experience what the person is going through. So we literally try to have the person, if it's not mandatory. And then there's also obviously whether or not you immediately need to call medical attention. So if someone's taking drugs. So I think there's a broad level of training that goes with it.
And in that training, or is the tased officer asked to do things? Is he instructed to get up or to go down, or how do we register? How does a tased person respond to instructions?
Oh, so if you're telling someone they're tased to then do something.
Right.
Okay, so I mean, I think what you have to know is it incapacitates them for a few moments where they're not going to be able to do what you wanted them to do. And so there's, and what I will say, having been tased, I knew it was coming. So for me, it was just the physical stress. But I think for someone who is in a situation that they're not the police and they're on the receiving end of it, obviously the level of stress will be significantly high.
Okay, thank you, Chief.
Ms. File, anything?
I had a quick question. Chief Shields, good afternoon. I had a question to the fact of the immediate emergency situation. Would the idea of dismissing the police immediately in this particular case help in keeping, say, the energy of the city at a lower level, or would it give, say, in a mob situation or in the groups that congregated, that they would feel more protection as opposed to the police feeling protection? Maybe I might be asking two things. I'm saying to the point of, to dismiss police, would that give a mob a feeling that they had more, there was more leniency for them and that they could continue if they were doing anything negative?
Oh, I don't think so. I mean, I think, so it's not, we were talking a couple of people for a specific action. And so, no, I mean, that was the whole point. Saturday night, because we had these other agencies and we had the National Guard, we finally were getting a handle on things and things were finally starting to settle down. And the problem with the incident was it just caused so much anger that everything started to rise up again. And so I don't think that they were trying to win. I think what they saw is, we're here protesting George Floyd, and now there's two people in a car and they're tased, guns pointed at them and hauled out because they're in a car in traffic. So it's, I didn't sense, no, and that didn't happen, quite honestly. Things kind of seemed to subside again once the terminations were announced. So no, it didn't give, I understand what you're asking, but in this particular instance, that wasn't the cause and effect, no.
And so, Chief Shields, question for the calendar. You have talked about 2 days that this was going on. I'm assuming, and for the record, I want to make sure it's clear, that's Friday, the 29th, and Saturday, the 30th, right?
Yes.
And then Officer Streeter, Investigator Streeter, and whoever else, you dealt with them with discipline on the 31st.
Correct, yes. Yes,
which
ma'am.
was a Sunday.
Yes, ma'am.
Okay. That's all I had. Anybody else have any questions for Chief Shields? And yes, I think she should be reserved, but at this point, any further questions of Chief Shields? Go ahead, sir.
Follow up based on y'all's questions. Is that permissible, Your Honor?
Yes, go ahead.
Chief, the city of Atlanta tracked how many arrests were made, correct, during those dates? Media was asking for them. Your PIOs were getting driven crazy about it.
Yes.
If I told you there were 157 arrests made on Saturday night and only 64 made Sunday night, would that surprise you?
No.
I don't have any other questions.
Anything, Ms. Lawrence Hardy?
Not for me. Thank you, Madam Chair.
All right. So, Ms. Harmon, Chief Shields needs to go to a witness room. And then we are at the point where, does the city have any more witnesses to call?
We do not, Your Honor.
You rest?
We do.
All right. So for the appellant evidence?
Yes, Your
Go
Honor.
ahead,
First
sir.
person we would call is retired Major Rick Mason. And Ms. Harmon, to speed things up, the next witness we'll be calling is SPO Norman Merritt, Merritt.
Thank you.
Yes, ma'am.
So Mr. LoRusso, Mr. Mason needs to be told to turn on his video and his audio.
I
You
can
see, he's there, but
yeah.
there, he did his audio. Now the
Major,
video.
are you able to have video for us? Oh, there we go. Can you raise your right hand, please, sir? You swear or affirm the testimony you're about to give before the board is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Can you state your name, please, sir?
Richard A. Mason.
And are you currently retired from the City of Atlanta Police Department?
I am.
How long did you work for the City of Atlanta Police Department?
A little less than 28 years.
And when did you retire?
August of 2020.
And on May 30th, 2020, what was your role with the City of Atlanta Police Department?
I was a major in the code enforcement section, primarily responsible for the protests going on throughout the city of Atlanta.
Were you actually actively engaging and supervising officers on the ground on May 30th, 2020?
Yes.
Can you describe briefly the dangers presented to officers on the street that night?
It was unlike anything we've ever encountered before. I came on at the end of the Rodney King riots, worked Freaknik, the Olympic bombing. 9 years of undercover in Occupy Atlanta, I've never seen anything like it. It was complete and utter chaos. People were throwing bombs at us. They were throwing bricks, frozen bottles of water. They were running throughout the city, destroying everything in their path. It was horrendous.
How often were reports of gunfire or the sound of gunfire down in downtown in this area?
We heard gunfire so often we stopped reporting it. It was useful. It's like reporting fireworks on the 4th of July. It wasn't worth the radio traffic.
And you were aware that night of the executive order placing a curfew in place?
I was.
And on May 30th, 2020, do you recall Chief Shields coming over the radio and ordering officers to start making arrests when the curfew went in place at 9 o'clock?
I recall the order and arrests were being made at 9 p.m.
At one point, did you not have to use 400 National Guardsmen to try to keep protesters from destroying property?
On the 30th, we used 400. On the next day, we used about 600, yes.
Are you familiar with Investigators Streeter and Gardner and their role on the fugitive unit?
Yes, I am.
And how well trained are fugitive investigators?
Fugitive trains monthly in their tactics.
At the time on May 31st or May 30th, 2020, you had a background and knowledge of all City of Atlanta police policy and state law regarding the use of force?
Correct.
And you had an opportunity to review the videos that were put in evidence and that were stipulated to regarding this incident?
Yes, sir.
Did you witness, as a major with the City of Atlanta Police Department, any violations of City of Atlanta policy?
Only the use of profanity, but it was one time. Other than that, nothing with use of force.
At any time, did you see any violations in those videos of state law?
No, sir.
At any time, did you see any violations of any custom or practice or higher way of doing things that was imposed by the chief by her ethos?
No, sir.
Do you believe the videos that you saw justified a charge against Investigator Streeter of 4.2.50 maltreatment or unnecessary force?
Absolutely not.
I have no further questions for this witness at this time. I may have some cross.
Ms. Lawrence Hardy.
Thank you, Madam Chair.
I do have a question before we begin, Your Honor, and I'm sorry to interrupt you, Allegra. I was under the impression that our cross-examination and our direct counted against our time of 90 minutes. Is that the case?
Should be.
Well, then,
We've got a hearing in 56 minutes, me and my other panel members, so we're trying to just blow through this.
well, Ms. Allegra Hardy passed an hour and 30 minutes about 10 minutes ago.
Well, then she better be quick. Ms. Allegra Hardy, make it very quick.
Will do. Major Mason, you were not involved in any way with the decision to terminate Mr. Streeter, correct?
Correct.
You were not physically present at the scene with Mr. Streeter on the evening of May the 30th, correct?
No, ma'am, I was a block away.
Is that correct?
I said, no, ma'am.
Well, so it's not correct? I believe it is correct. I want to make sure the record is clear. Is it
Yeah,
correct to say
question
that?
again?
Absolutely. You were not physically present at the scene with Mr. Streeter on the evening of May 30th, 2020,
The
correct?
statement is correct.
And you would agree that the chief of the APD is the only one who has the authority to fire an Atlanta Police Department officer. Is that correct?
Yes.
Thank you. Madam Chair, I tender the witness.
Anything else, Mr. LoRusso?
Major Mason, the chief can fire people, and you've certainly seen people fired in discipline. Are there policies, procedures, and ordinances that have to be followed in order to do that?
Just a small thing called due process.
Thank you.
Anything further, Ms. Lawrence Hardy?
Not for this witness, Your Honor. Thank you.
Okay. Major Mason, thank you so much. You are released from your witness subpoena, and please don't discuss your testimony with anyone. Thank you. Happy retirement.
Thank you, ma'am.
Next witness would be SPO Merritt, as I understand it.
Yes, and the on deck, Ms. Harmon, will be Captain Brian Schiefbauer. And pull up the TASER policy and get it ready. The 4.2.1 section, and then the 4.3.1.
Mr. LoRusso, I do want to make a note that it appears that Sergeant Crayer and Merritt are on the same connection, just FYI.
I think it would be appropriate, Your Honor, avoiding the appearance of impropriety, just to ask Sergeant Crayer just to step out of the room. I think that's the only way we can resolve this. I know people are trying to get to cameras to participate.
I think that's reasonable. You gonna ask him? I'm gonna ask him.
I'll be more than happy to ask him. Is he
Okay,
up on the
please.
screen?
I don't see him yet. I'm not sure because the exhibit's been put up. So let's see.
SPO Merritt, are you with us?
Yes, he's there.
Okay, I'm not hearing him.
Can you hear me now?
Yes, I can. Can you raise your right hand, please, sir?
Get out of here.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
And if you can just confirm for us that Sergeant Crayer has left the building, if you will.
Yes, he has stepped out of the room.
You are a trainer at Atlanta Police Department?
That is correct.
And are you a post-certified trainer in the use of force and taser?
I am.
Are you familiar with the taser policy, the conductive energy weapon policy for the city of Atlanta?
I am.
And do you recall providing in-service training or initial taser training to the officers in the fugitive unit?
I don't know if the officers in fugitive unit, I've trained it, but I don't know if they were there when I've trained it. It's trained on a frequent basis.
Is it fair to say that you train a lot of officers for the city of Atlanta? So as they come through, you just train whoever's in the seats?
I train veteran officers, but yes, that's my full-time job.
And you have been on the receipt of former Chief Shields' impressions and You're familiar with her mandate so far as use of force and how officers should deliver use of force?
Yes.
And the taser policy that's up, you would agree at 4.2.1, 4.2.2, the officer's decision to use a taser is based on their reasonable subjective belief that there could be a physical arrest taking place or that there is resistance, active resistance, correct?
Correct.
So if an officer is experiencing active resistance, which is non-compliance plus, if you will, it is reasonable under the policy and the taser training for them to deploy a taser, correct?
Correct.
And you agree from 4.2.2, a CEW deployment is to prevent further escalation of a situation and to minimize injury to the officer, suspect, or a third party. Do you agree with that?
Yes, I do.
Have you been exposed to a taser, sir?
6 times.
I have too. It's a completely unpleasant experience, but it does allow you to take someone into custody without a physical fight escalating, does it not?
Yes, it does.
And do you agree that de-escalation requires the cooperation of the officer and the suspect, and if the suspect doesn't comply, there will be no de-escalation?
Correct. That's a key element.
Now in 4.3.1, it says the subject initiates active physical resistance to defeat an officer's ability to effect arrest. That's also a justification to use a taser, is it not?
It's in the policy, yes.
Now, you were present at the scene when Messiah Young was arrested, were you not?
I was.
And you saw Messiah Young trying to pull the taser probes out of his passenger, did you not?
I did not see that. It was an extremely chaotic situation. When I got there, no, I didn't. I personally did not see that.
Did you witness Investigator Streeter's use of the taser on May 30th, 2020?
No, I got there after the fact. We had walked up once the taser had already been deployed.
Did you see any violations of policy as you were sitting there as a training officer with the city of Atlanta?
No.
And just for the benefit of the panel members, the use of a taser is not deadly force, is it?
No, the use of the taser is not a deadly force, and it is a de-escalation tool.
So I think you broke out. You said the taser is a de-escalation tool?
Part of what we train is to use it partially as a de-escalation tool.
And if a person gives the appearance to an officer that they are in possession of a weapon, trying to retrieve a weapon, or escalating their physical resistance, do you believe and do you train for the City of Atlanta Police that it is appropriate to deploy a taser?
Yes.
That's all the questions I have for this witness.
Ms. Lawrence Hardy?
Senior Officer Merritt, I understand you have an opinion about what happened here, but you were not authorized to decide whether or not to terminate Mr. Streeter. Is that correct?
That's correct.
Your Honor, may I object a moment? How much more time are we going to afford the city when they had an opportunity to decide whether they wanted to use 1 minute or 91 minutes to cross-examine to put their direct up of one witness? Now, I would be held to that standard, and I would be denied any cross-examination if I took an hour and a half to cross-examine Eric Shields.
You don't know that. Ms. Lawrence Hardy, last question.
When you arrived at the scene, you were unable to identify the officers at the scene because of the face mask. Is that correct?
Because of everyone had donned a gas mask, and yes, I was not able to identify them because of their gas mask. Right.
Thank you.
Ms.
Judge, one
LoRusso,
thing.
anything else? I'm sorry. Hang on.
All right. No,
Mr.
Your Honor.
Alameen?
Yeah,
Hang on just a second, Mr. Alameen.
I just want opportunity to get a little more clarity on this one point. Officer Merritt, I see where it said in this, when employing the taser, it mentions verbal commands. I didn't get a chance to read what came below that, but what is the training in terms of how a person is expected to respond to verbal commands after they are tased?
I'm sorry, I'm not totally tracking on your question. I'll answer the best I can.
Let me, okay, you understood what I was asking though, right?
That how do we expect them to respond to verbal commands once someone's been had a taser or a control, a TW exposure?
Yeah.
Is that your question?
Yeah, what's the training on that?
It really varies. From personal experience and through training, you're going to get a wide variety of how people respond to the taser. Everything from total compliance to it having very little effect. Both we talk about in the training class and through my personal experience, you see those things. So there's not a specific, a taser exposure does not always equal the same response.
Okay, I'm asking a little different. What's the level of comprehension? Is a person mentally is he
Incapable.
having difficulty hearing commands and responding to commands when they are tased? Is it?
In my experience, no. Once what's unique about the taser is once that cycle is over, there's very little residual effect. And they can hear your verbal commands. That's not the way the taser works. It doesn't really affect hearing per se, but they can hear verbal commands both during and after.
And do they have body control? They can hear the command, get out the car after they're tased, but do they really have control over their bodies to get out of the car?
When the taser is cycling or once that 5-second cycle is completed? It's different.
Yeah, both. Give me both.
Well, it really depends. First, let's talk about when it is cycling. It really depends if you have a good connection where both prongs have hit and the prongs are spread. Many people, once again, there's not a universal answer. Many people will have a very hard time. We get what you call neuromuscular incapacitation, where they have a hard time doing complying to any type of verbal command. Some people can, which I have seen. If there's not a good connection, there's a lot of reasons why the taser might not give a good connection.
Okay.
Once that 5-second cycle is over, they can be 100% fully compliant. There's no residual effect. They have full control over their facilities after that 5-second ride is over.
And so what I was really trying to get is, so that's the training, is that you don't know what to expect in that first 5 seconds, but after 5 seconds, then a person is fully responsive. Is that the training?
They have the ability to be, yes. Once that cycle is over, once that 5-second cycle with the taser, that neuromuscular incapacitation that they receive on a good taser connection is no longer there. Once the cycle is over, or once both prongs go with outside of a 2-inch limit and you don't, or distance from the person, you're not going to get the neuromuscular incapacitation, which in turn, that neuromuscular incapacitation is what makes them sometimes difficult for them to comply with verbal commands.
Okay, thank you, sir.
Thank you.
Ms. LoRusso?
SPO
Anything?
Merritt, yes, I'm sorry. SPO Merritt, one of the things that you train is to cuff under power. So while the person is going through the cycle of the taser during the NMI, the neuromuscular incapacitation, you're trying to do everything you can to either handcuff them or put them in a safer position from the officer, remove them from an unknown area, do something to affect the arrest, correct?
Correct.
And as you said, they can hear commands while the taser is going on, while the cycle is going on. And your hope is that when the cycle stops, you either have them in custody if they're subject to arrest, or they are compliant when the cycle stops, correct?
That is correct.
That's all I have. Thank you, Your Honor.
Anything from the board? Hearing nothing. Okay, next witness.
Next witness.
Oh, I'm sorry. Sir, I forgot to say to you, well, he's gone. He can't discuss his testimony. Is he gone? Yes, he is. All right, go ahead. Next witness.
Captain Schiefbauer, and next up will be Officer Tabitha White. Okay, go ahead and pull it up. Just have it sitting there for him. Your Honor, if you could let me know, I don't see him. Is he up?
Yes, he is.
Okay. Can you
Major
raise-
shift hours there. If you click through the screens, the video screens, you'll
Oh, I
find him.
see. Thank you. It's so simple, even a lawyer could do it. Hang on. There he is. Okay. Can you raise your right hand, please, sir? Do you swear or affirm that the testimony you're about to give to this board is the truth, the whole truth, and nothing but the truth, so help you God? And if you can take yourself off of mute.
Okay, I do.
Thank you. And I'm sorry I demoted you, Major. You are now a major, and you've been promoted since May 30th, 2020, correct?
That is correct.
Congratulations.
Thank you.
What was your, on May 30th, 2020, your role was supervising officers on the ground, including investigators Gardner and Streeter?
No, actually, my role on the 30th of May was, I didn't have a role at that point, but I went down to the ground zero location to assist in any way I could because of everything that was happening. And I did have officers out there. That's why I went down to that location.
Now, following the incident, you were asked to review the incident reports filed by Investigator Streeter and people on his fugitive team and the videos, correct?
Just the videos, not the reports.
And you did so, correct?
Yes.
And following your review of the videos, if you had seen excessive force, you would have been obligated to report that to the OPS, Officer Professional Standards, correct?
Yes.
And you did not make a report to the Officer Professional Standards, did you?
That's correct.
And when you reviewed this email that's sitting there, if you need to review it just for your benefit, it lists at the bottom all of the videos that you reviewed. Sauls, Gardner, Streeter, Hood, Smith, and it says no weapon observed in the videos, correct?
That's correct.
Now, you know from reviewing videos, and you were charged with reviewing them for this agency, you know that the body camera is not always pointing where the officer's head is looking and their eyes are focused, correct?
That's correct.
So would it surprise you if officers saw a gun or saw an impression or actions indicating somebody was trying to pull a gun, but it didn't show up on their body camera?
Not at all.
Now, you sent out this email, and this email was to summarize your impressions of the review, correct?
That's correct.
And the email does not state these officers used excessive force, these officers should have de-escalated. You don't state the officers did a thing wrong, did you?
That's correct.
And who did you send this email to?
I sent the email to Deputy Chief Stacy Gibbs and CC Major Fred Watson.
Now, Major, I don't want to make you feel uncomfortable, and I understand you have people to supervise, but if you thought there was a violation of policy, would you have raised it in this email, and would you have referred this to Internal Affairs?
Based on the totality of the circumstances that I knew, which just was watching the body cam video, I didn't conduct an investigation. I didn't speak with officers in depth. I didn't conduct a formal investigation on it. Based on the body cam video, that's correct.
Would it surprise you that nobody ever spoke to these officers, specifically Streeter, before he was terminated?
Yeah, actually it would.
That's not supposed to happen, is it, Major? You're supposed to investigate a use of force by speaking to the subject officer. That's City of Atlanta policy, is it not?
That is correct.
That's all the questions I have of this witness.
Ms. Lawrence Hardy?
I do just have two quick questions.
And Your
the
Honor,
first-
I just would like a standing objection to any cross-examination you're giving.
It is. We're wasting time on that. Go ahead, ma'am.
Major, in viewing the footage, you did not actually observe Mr. Young with a weapon at any time, correct?
That's correct.
And no weapon was ever recovered on Mr. Young's person or in the vehicle he was driving. Is that correct?
To the best of my knowledge, that's correct.
Thank you.
Okay, that's the two questions. Thank you, ma'am. Anything further, Mr. LoRusso, of this witness?
No, Your Honor.
Major Schiffbauer, thank you. You are released from your subpoena. Please do not discuss your testimony with anybody. And again, thank you.
Yes,
Next
ma'am.
witness.
Thank you.
Next witness is Tabitha White, and Lieutenant Peterson is up after that. Just get that exhibit up.
And Mr. LoRusso, while that's going on, is any of this going to be redundant? And I know your objection, your standing objection to giving the city more time than they should have had. I understand that, but I'm just trying to help you cut through some of this.
No, I appreciate it, Your Honor, because sometimes, as you know, you've tried enough cases. Sometimes from the lawyer's perspective, we're trying not to be. So I appreciate the admonition. I am doing my best not to have anything redundant. And as I'm going through, I'm trying to make notes to further ensure. But I can assure you that these witnesses will be quick.
Okay, and I just want to tell you, we got a hard stop, like it or not, about 1:45, because I have to let Ms. File and Mr. Elamine do anything like eat between then and 2 o'clock. We've got a 2 o'clock starting, so I just want to make you aware. Go ahead, sir.
I don't see a video for Officer White.
She's there. Click through your.
No, I see her location, but I don't see her video.
Right. Okay, there we go. Magic.
I still don't see her, but can you raise your right hand, officer?
We can't hear her either. Okay, she's got.
The
Officer
video
White,
won't let me. Yes, sir.
can you turn your video on?
I'm trying. It won't come on.
Okay, that's fine. Can you raise your right hand, please?
Yes, sir.
You swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth? I hope you got it.
Yes, yes, sir.
Are you familiar with an email that was sent from then Captain Schiefbauer to Major Stacy Gibbs and Major Fred Watson on Sunday, May 31st at 6:01 p.m. concerning his review of the videos involving Investigator Streeter, Investigator Gardner, and the fugitive team?
I didn't read the email, but I was instructed to recall an email that day from Major Watson.
When you say recall the email, do you mean remove it from the server?
No, sir, to remove it from being sent to other recipients.
So there was an effort made by the command staff to prevent Captain Schiefbauer's email from being disseminated to the department. Is that a fair statement?
To be sent for the, I guess it was being sent to command staff and other people that was on an email chain, yes.
That's all the questions I have for this witness.
So, anything on fire, Ms. Lawrence Hardy? One question.
Just to be clear, you don't know whether it was this email or not, Ms. White, because you did not read the email, correct?
No, I didn't read the email.
Okay. Next witness, Lieutenant Peterson, I believe, right?
Yes, Lieutenant Peterson.
Ms. White?
On deck. Would be
Officer
Sergeant
White?
Flynn.
Yes,
Officer
ma'am.
White, thank
Yes,
you so
ma'am.
much. You are released from your subpoena. You are good to go about your day. Do not discuss your testimony with anyone.
Okay.
Thank you.
On deck, Ms. Harmon would be Sergeant Dean.
Not Peterson.
No, Peterson's up, and then on deck is
Oh, sorry.
Peterson should be joining shortly.
okay. Thank you. Pull his letter up, Kim. I don't have the number. I'm sorry. 22.
Can you call him out of, oh, there he is. You
I was
see him,
just
Mr.
thinking that.
LaRusso?
I was just thinking that, Your Honor. Hang on a second. Let me see if I can get him.
He's here. He's here. His
I-
video isn't on.
Right. He's on mute too, so I need him on his mic on so I can give the oath. Lieutenant Peterson, can you raise your right hand, please, sir? Swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
It is.
And Lieutenant Peterson, I'm going to show you an exhibit that's up on your screen. Can you see that?
Yes.
And did you author that letter?
I did.
And you are Lieutenant in Internal Affairs?
No, I'm the Lieutenant in Open Records.
Okay, Lieutenant Open Records. And you sent this letter confirming that there were no recordings of any interviews of Investigator Streeter or Investigator Gardner regarding this incident that we're here about today, correct?
That's affirmative.
That's all I have from this witness.
Okay. Next witness. Oh, Lieutenant Peterson, thank you. You're released from your subpoena. You're good to go. Don't discuss your testimony with anyone.
Thank you, ma'am.
Next witness would be Sergeant Dean, and on deck would be Officer Carlos Smith.
I think he's there. Yeah.
Okay. Sergeant Dean, if you could raise your right hand, please, sir. Do you swear or affirm the testimony you're about to give in this hearing is the truth, the whole truth, and nothing but the truth?
Yes, sir.
What is your role with the City of Atlanta Police Department?
I am a sergeant assigned to internal affairs, and I work in the advocacy unit.
And in part of the advocacy unit, are you involved in the notice of proposed administrative action and notice of final administrative action, specifically with the termination of employees?
Yes.
When employees are presented with a notice of proposed administrative action, are they supposed to be given a meaningful opportunity to respond?
Yes.
And are they entitled to have a union representative present when they do so?
Yes.
And were you notified that Investigator Streeter was going to be terminated?
Yes.
After the fact or before?
Before.
Did you notify anyone or voice your concerns about the fact that the City of Atlanta was not providing him due process and not following its policies?
I was not aware that there was not going to be a hearing. I was just notified to prepare the charges.
And in regard to your role in the advocacy unit with internal affairs, are you supposed to be involved according to the policies and procedures of the City of Atlanta with any termination or proposed termination?
Yes.
And you were not involved in Investigator Streeter's proposed termination or termination, is that correct?
The only thing that I participated in was to prepare the charges and at that point forward them to Chief Shields.
Did you voice your concerns that procedures were not being followed that were proper to afford him due process?
I made my concerns known to my immediate supervisor.
And did anybody change course based on what you said?
No.
And you were familiar with the ordinances of the City of Atlanta regarding terminations, not just policies and procedures. That's your job, right?
Correct.
And did you ever see any type of a statement specifically set out in 114.532 concerning what the emergency action was that required immediate action to terminate?
Can you rephrase that question?
Have you ever seen, with regard to Investigator Streeter's termination, any specific statement as to why this was an emergency situation or treated as such?
No.
And just to confirm, you were in Internal Affairs on May 31st, 2020?
That's correct.
And you were in Internal Affairs on May 30th, 2020?
Yes.
Was Internal Affairs, OPS were they ever called out to do an investigation of an allegation of excessive use of force or improper use of a conductive energy weapon?
In which incident?
In Investigator Streeter's incident?
No.
Should they have been according to the policies and procedures of the City of Atlanta?
According to the policies, that should have been investigated by the Office of Professional Standards.
And the Office of Professional Standard did not do any investigations concerning Investigator Streeter's use of force, correct?
That's correct.
So as far as you know, in the normal course of business, when an officer is accused of excessive force, OPS asks them why they used the force, what they were experiencing, and what their basis was, so you can investigate whether or not they were trained properly, not trained properly, just a bad officer, or whatever reason, correct?
Usually an investigation is conducted, and at that time, the employee will be able to provide
statements. He would have a union rep, and he will be able to give his account of what transpired.
And that didn't happen in this case, did it?
No.
That's all the questions I have of this witness.
Sir, thank you for your testimony. You are good to go. You're released from your subpoena. Please do not discuss your testimony with anyone.
Okay, thank you. You have a good evening.
Thank you, Sergeant. You too.
My next witness would be Jamie Borden, and I'd like the chair to clarify something for me. By our count, I'm at about 41 minutes, which means I would have 49 minutes left, and 1:45 is 15 minutes from now. So what are we planning to do with the other process and time that this officer has to defend his career?
That's why I asked you if any of this was redundant,
And I don't
because
think
we
it
have
has
a
been.
hard stop.
And I don't believe it has been, Your Honor. I've been very diligent in making sure that I don't know what these witnesses are going to say because I can't interview them. They're represented by the city. So I have a lot of people on that witness list that I did not call because I was able to get the information I needed.
Okay, so I can't tell you how to run your case. I'm just telling you what's going to happen because I can't make Ms. File and Mr. Elamine go forward for another 3+ hours potentially for a hearing without giving them lunch. So we're going on to who's the next witness?
Jamie Borden, if you could call him up, and then on deck would be Ivory Streeter. And for the record, Your Honor, I respectfully object to any of my time being cut off. We have been very diligent. We have worked hard to stay within the parameters. The city has received not only their time, they have received more than their time. And I believe that affects my client's ability to present his case.
I understand your concern. It's been noted for the record. Mr. Borden is present.
Can you take your phone off, your computer off mute? You hear me? Can you raise your right hand, please, sir? You swear or affirm that the testimony you're about to give before this Civil Service Board is the truth, the whole truth, and nothing but the truth? So help you God?
I do, sir.
Can you state your name for the record, please, sir?
James W. Borden.
And how are you employed?
Self-employed right now through my company, Critical Incident Review.
And what does Critical Incident Review do?
I'm an investigative specialist and I lecture across the country regarding investigative strategies, the cognitive interview, and the importance of investigations.
Are you retired from a police department?
Yes, sir. I'm recently retired from the Henderson Police Department in Nevada.
And what was your role in the Henderson Police Department in Nevada?
I was the sergeant over the use of force training and analysis unit as a component of the training bureau for that department. So I was a sergeant over the entire training bureau, and then I had my own unit that did all of the use of force training and analysis, investigations, and so forth.
Do you have any specialized training and experience in investigating use of force incidents or applying policies to use of force specifically through reviewing videos and reviewing reports?
I do.
Do you have any specific and specialized experience regarding investigating use of force incidents, including whether or not officers should be interviewed prior to making decisions?
Absolutely.
Exhibit 38, I would submit, is a copy of Jamie Borden's curriculum vitae and a Rule 26 witness list. I'm not familiar with all of the panel members. If you are not a witness, if you're not an attorney or don't deal in federal courts, a Rule 26 witness list is an expert list that they provide when they testify in court. Can you tell us how many courts you've been qualified in as an expert in the topics I just mentioned?
I'll have to take a look at my list. I don't have my list in front of me, Lance. I'm actually lecturing in Salt Lake City. So I'm going to give you an estimation of, I have approximately 117 cases. About 40% or about 60% of those are Rule 26. And I've been qualified in approximately 13 different cases and jurisdictions.
And those would be federal and state courts?
Yes, sir.
And have you ever testified against an officer before?
I have not actually testified against an officer, but I have 3 active cases against officers at this point in time.
At this point, I would tender Jamie Borden as an expert in investigations of use of force incidents and the application of policies, the appropriateness of investigations, and I believe he can add a great deal of information to this board, specifically with the 3 points that were outlined in your response to the motion in limine and your order.
Madam Chair, I
Ms.
believe.
Lawrence Hardy, I am I am skeptical of allowing you to respond to that. I know you have an objection to this gentleman being called as an expert, correct?
That's correct, Your Honor.
And so, Mr. LoRusso, here's my question to you. According to the order that I issued in your motion about Mr. Borden, my recollection is that I said that his testimony, anybody's testimony, should be limited to their personal knowledge of either this incident or the city of Atlanta or something like that, right? So what is it, Mr. Borden? Can you put up a proffer of what it is Mr. Borden's going to testify to?
Absolutely. Your statement said any testimony that is not specifically related to Atlanta Police Department policies or procedures, the appellant's alleged conduct on May 30th, 2020, or the meted discipline in this case is prohibited. There's nothing about personal knowledge, and I believe this witness has the ability to give insight to the board on those 3 topics.
Okay, so why does he need to be called as an expert then?
Because
why does he need to be a spurt?
Why does he need to be a what?
Why does he need to be an expert? I mean, what is it you're getting with him being an expert?
What we have been told through the testimony of one witness from the city is she looked at a bunch of video. She decided something was incorrect. She didn't have time to do a proper investigation. She didn't have time to do a thorough investigation. And she was, in her word, ticked off. She didn't speak to any of the officers prior to making a recommendation, prior to determining whether their force was appropriate. And this witness specifically does use of force investigations for a living, has had judgment passed on him by over 22 courts that he can give insight into the propriety of this process and whether or not it was appropriate to terminate based on those videos. And then overall, looking at the videos, was the actions proper based on law enforcement standards and the Atlanta police policies and procedures?
But does he have actual experience with APD?
No, but I don't believe he needs actual experience with APD to be an expert. That would basically say if he hadn't worked for APD, hadn't consulted with APD, then he could never be an expert. I can assure you, people sue the Atlanta police and defend the Atlanta police all the time from around the country, and they may be in Atlanta for the first time when they fly to Hartsfield for their deposition.
So 2 things. I want to tell you that we spent 15 minutes by my note this morning arguing or listening to y'all arguing about Mr. Borden and whether or not he should be allowed to be exempted from the rule of sequestration. So that's going to count, against your time in some fashion, not entirely, because you didn't talk the whole time. Back to this issue of him being an expert. This board is not a federal court. We are not a court of law. We can allow whatever witness to testify that we want. And if we let them testify, then we can take, in evidence, we can decide what weight to give their testimony. So having said all of that, Ms. Lawrence Hardy, I'm going to allow him to testify to whatever it is he's going to testify to. But I just remind you, Mr. LoRusso, you need to be quick.
Mr. Borden, have you had an opportunity to review the incident reports and the videos concerning the use of force on May 30th, 2020 regarding Investigator Streeter?
Yes, I have.
And are you aware that Investigator Streeter was never interviewed prior to making a determination as to whether or not his actions were appropriate under the policies?
Yes, I've seen nothing reflecting an interview of any kind.
Can you tell this board the propriety of terminating an officer or making an adjudication on their use of force without interviewing them and without getting their understanding of what they were perceiving and seeing at the time in light of the City of Atlanta policies and national standards of law enforcement and the prevailing case law from the United States Supreme Court.
Madam Chair, I'd like to just ask that the witness be directed to answer in compliance with this board's ruling on the motion in limine, which does not speak to national standards or the United States Supreme Court precedent, but is on.
I agree with Ms. Lawrence Hardy. Mr. LoRusso, you need to tailor your question accordingly.
Can you answer that question with regard to City of Atlanta policies and procedures, and specifically the case of Graham versus Connor, which is replete, written at least 3 times in City of Atlanta policy as something the policy is based on and officers are required to follow?
Yes, sir. And to that end, Graham, it's section 5.6, I believe, in Standard Operating Procedure 3010, use of force. It directly refers to Graham versus Connor, which is not uncommon in policies across the country. And I will say that the policies that I've reviewed for APD are some of the most eloquently and articulated policies I've encountered in this country. They're very well written. They're very thoughtful. In that section, it refers directly to the decision in Graham versus Connor as it relates to the investigative process of an officer's involved use of force. The perspective of the officers, I'm sorry, did I step on somebody there?
No, I'm just saying that I have 3 minutes.
Okay. So yes, I can answer to that. And yes, it does directly affect the investigative process. The policies are very solid and thoughtful. There was no investigation, which is strange to me. I looked for connective tissue between everything that happened, and everything that I've read in Standard Operating Procedure 3010, 3042, 2020, talking about discipline. There's no connective tissue between the integrity of the department and the investigative process that's in place for an officer involved use of force and the allegations of wrongdoing or maltreatment and how the department got to that decision. I can't find any connective tissue in that. All I see is evidence of a use of force. That the only evidence we really have is a statement and the video, which is not enough to do a thorough investigation, which it's stated in policy that a thorough and complete investigation will be completed on allegations of maltreatment or excessive or unnecessary use of force. And we don't have any of that here.
Okay, and I hate to cut you off, but you have reviewed these videos. You've looked at the use of the taser and the use of force that was conducted on May 30th, 2020. In your opinion, as a taser instructor and an expert, do you believe the taser use and the use of force was appropriate?
Based on the information I've got, Mr. LoRusso, yes, there's nothing to say that these officers did not have a lawful objective and goal in the use of those tasers, the deployment of those tasers. They were very decisive. They were very quick. They achieved their lawful goal and they moved on to the business at hand.
Thank you. That's all I have from this witness. My next witness would be Ivory Streeter.
Mr. Borden, thank you so much. Enjoy your time in wherever you are. Salt Lake City, you said?
No, how much
yes.
time do I have?
And please do not discuss your testimony with anybody. You are released from your witness subpoena. Thank you, sir.
Thank you, ma'am.
Swear in Mr. Streeter, please.
Please raise your right hand, please, sir. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Hang on a minute. Can you state your name for the record?
Ivory Streeter.
And how were you employed on May 30th, 2020?
I was an investigator with the Atlanta Police Fugitive Unit.
And how long had you been an investigator with the Atlanta Police Fugitive Unit?
I've been with the Fugitive Unit approximately a little bit over a year.
Mr. Streeter, I'm sorry. It's really hard to hear you guys.
I think you all I think you all in the same room. That's the problem. Mr. LoRusso,
I think it should have stopped
you
now.
and the Pellin are in the same room.
So far as the fugitive unit, how many violent fugitives have you arrested in your time with the city of Atlanta?
Hang on, Mr. LoRusso. Ms. Court Reporter, can you hear Ms. Court Reporter?
Violent individuals.
Ms. Court Reporter, can you hear?
Are you able to hear me?
I can hear everybody except for the witness, which I was trying to say before Mr. LoRusso continued questioning.
Say, with my time to the Atlanta Police Department, hundreds of violent individuals that I've arrested.
Your Honor, are you able to hear this witness?
I am. I just wanted to make sure, more importantly, the court reporter could.
You can?
Are you all in the same room?
We are, but we're limited a little bit. And
can you use the same? We don't have to see you. We can use the same laptop of what that's all the reverberation.
Oh, I understand. Yeah, let's see. Hang on. Hang on. Okay, are you able to hear us now? Thank you for the suggestion. So in the 15 years you were with the city of Atlanta, is it the case that 11 of those years you received a highly effective on your evaluations?
That's correct.
We have in front of us a policy, the use of force policy for the city of Atlanta. Are you familiar with that?
Yes.
And were you governed by that policy throughout your actions on May 30th, 2020?
Yes.
And with regard to the officers who were on the scene on May 30th, 2020, did I ask you to find out and add up the number of years of service the officers had?
Yes.
And you agree that it's 120 years of service?
That's correct.
And this is a team you work with on a regular basis?
Minus two of the guys, yes.
And is it a fair statement that the night of May 30th, 2020, you were designated as an arrest team, an apprehension team, correct?
Yes.
At this time, I'd move to admit the use of force policy.
Any objection?
No objection.
It's in the record.
And did you work as a task force officer, a TFO?
Yes.
And what is a TFO?
So TFO is for task force officer, and I have held a position with the GBI.
Did you work with the GBI on specialized assignments?
Yes, it was in a narcotics realm.
And how long did you do that?
Approximately a year and a half. I participated as a task force officer.
Is that a prestigious assignment within the City of Atlanta Police Department?
Yes, you're assigned from a position in the narcotics unit to a specialized position with another agency such as the GBI or the DEA.
Now, I'm trying to cut to the chase here. Why did you and the other officers approach the vehicle that was driven by Messiah Young?
At the time, there was an incident that happened prior to where an individual was taken into custody for entering the roadway and stopping the vehicle that Messiah Young was driving. At the time that I approached the vehicle, he was under arrest and had committed charges that we were going to arrest him for.
And was Messiah Young told to drive away when the traffic was clear for him to do so?
Yes, he was told several times by my supervisor, Lonnie Hood, to drive away, and each time would attempt to, elude us once we went up to the vehicle.
At the time that you came up to Messiah Young and first contacted him, was he in violation of the curfew and subject to arrest?
The first time I got close to the car was he actually drove away from my supervisor, did a short drive away from him. He was told after that to keep driving. And
the first time you contacted him was after the curfew was in place. So was he subject to arrest at the time you first contacted him?
Yes.
And was he subject to arrest for obstruction of an officer for nearly knocking your sergeant off of his feet when he tried to open the door?
Yes.
And were you trying to effect a lawful arrest when you approached the vehicle?
Yes.
Can you tell this board why you had your gun out when you initially approached?
It was a chaotic scene. Shots were being fired in the area. We had, firework mortars being shot at us. And when I went to the vehicle, Mr. Young started reaching into his pocket, and I saw the impression. We carry Glock handguns, which has the top of the gun has a square backing, which is kind of unique. He reached into his pocket, and I saw an impression that was the same as, impression that you would get from this type of gun. That doesn't happen, as an officer. You go up to someone, people don't reach into their pockets and, actively just try to pull things out of their pockets. So it raised my suspicions, with the shots being fired in the area, everything that was going on, that something was possibly about to happen to us.
So then you holstered your gun and assisted in officers' efforts to take him into custody, correct?
Yeah. So he stopped trying to go into his pocket for a second, which I transitioned to my taser. The window was broken out, and he again went to his pocket again, and at the same time was trying to remove prongs from the passenger side of the car, individual sitting in the passenger seat.
According to your policies and procedures of the city of Atlanta and your knowledge of law as a law enforcement officer, did that constitute active resistance and obstruction of a law enforcement officer?
Yes.
And did you deploy your taser at that point?
Yes.
Tell us why you deployed your taser at that point one time at Messiah Young.
I deployed my taser out of fear that I saw a window where, he had so much going on. He had a vehicle that could be used to hurt, officers that were standing around and also other pedestrians. So to prevent him from, going to a further panic, I tased him to disable him for a second so that he could be apprehended and be taken out of control of that vehicle that he could have used as a weapon.
Now, you said that he started reaching in his pocket again. By deploying the taser, were you trying to stop him from doing that so another officer wouldn't shoot him?
Yes, it was dual purpose. That's not something we want to do. With me doing that prevented, him from being shot by another officer who, saw him doing what he was doing.
Do you know why Messiah Young was reaching into his pocket when he was surrounded by police officers when he was being told to show his hands numerous times?
No.
Did you ever have any contact with him before?
No.
And we've been told that he's a college student. You had no idea whether he was a college student or what his role was at the time, correct?
I had no idea who he was.
If Messiah Young had obeyed the commands and driven away, would he have been taken into custody?
No.
Let's go to the time between when you were presented, we've marked as Exhibit A18, and the board has seen it. I'm going to try to save some time here. The notice of proposed adverse action and the notice of final adverse action. How much time elapsed between you getting those two actions?
It was minutes.
And were you ever told that this was an emergency action? And were you ever given anything that invoked the ordinance to say that this was an emergency action?
No.
Did you cooperate with Captain Schiefbauer when he asked you for information about the incident?
Yes.
How many hours had you worked on May 30th, 2020, when you finally stopped working that shift?
Well, we actually conducted two shifts, that same day. So I ended my prior shift earlier that, morning and came back in that evening.
So is it fair to say about 21 hours in a row you would work?
Yes.
Were you ever given an opportunity to give a response to the notice of proposed adverse action that is seen in Exhibit A18?
No.
Did you want to give a response to the chief of the notice proposed adverse action that you were presented on May 31st?
Yes.
Did you ever tell the chief you did not want to give a response to the notice of proposed adverse action?
No.
So between the time you received the notice of proposed adverse action and the notice of adverse action, you said it was a few minutes. Do you recall anything that Chief Shields said to you when she proposed between that time and when she was standing there with you?
She came out and said, which one of you want to do this first? And I said that my representation was about 20 minutes away. which I had already contacted. She said she didn't have time for that. I told her, I said, you know, if just let me get my representation here. She then left the office and was gone maybe 5 to 10 minutes.
And when she came back, what did she say?
She came back into the small lobby area, said, sorry, I had to do this, and walked away.
And she handed you the notice of final adverse action?
Yes, while saying that.
Investigator Streeter, did you believe there was a gun at play in this car when you were dealing with Messiah Young?
Yes, and like I said, I was positive in what I saw, and you know, afterwards, I searched for that gun. Maybe I searched for that gun for hours. You know,
when you say search for it, what do you mean? Who did you check with to see if the gun was taken into custody? We
had a property intake unit that was intaking property, and I assumed that one of the officers, you know, picked the gun up because of the chaotic scene and took it and submitted it as property. I checked with them several times. The vehicle was checked several times by myself, other investigators. Investigators actually went out to the tow yard afterwards and searched it again. So maybe, you know, at least 5 times.
So it's fair to say you were convinced there was a gun in that car and that's why you deployed the taser?
Yes.
Investigator Streeter, when you were working nights, when you were working in the rain, when you were missing Thanksgiving and your daughter's recitals, when you were going to work on holidays and missing your anniversary, did you expect that you'd get due process from the city if you were suspected of an allegation?
Yes.
And did anybody ever ask you why you used the force in this case?
No.
I'll pass the witness at this time.
Ms. Lawrence Hardy, one question.
Mr. Streeter, was a gun ever recovered from Mr. Young, Ms. Pilgrim, or anywhere in the automobile?
No, not by myself.
Nothing further.
Okay, anything further of this witness, Mr. LoRusso?
Nothing for this witness unless the board have questions.
Board have questions? Nope, I don't see them moving. Ms. Streeter, you know what I'm gonna say, but you get to sit here with us through the closing, and please make sure that you don't discuss your testimony except, of course, with your counsel. Thank you, sir.
Thank you.
Closing, city.
We would like to reserve and allow the appellant to go first.
Mr. LoRusso?
Your Honor, they have introduced evidence. That's completely inappropriate. They've introduced evidence and they've introduced testimony. It's ridiculous for them to now say that they can reserve their opening and wait until their closing and wait until I speak.
Well, that may be, but this is an administrative hearing, so I can't make her talk. Do you want to talk or do you want to spend 3 more minutes arguing?
Hang on, Your Honor. I'm sorry. I couldn't hear you. Sorry.
I said, do you want to talk or do you want to wait 3 more minutes? This is an administrative hearing, not a court of law, so I can't make her do anything.
You have in front of you, ladies and gentlemen, ample evidence that the city of Atlanta did not do an investigation in this case, violated their own policies, violated their ordinances. And as much as Chief Shields likes to talk about the expediency, I'll say 2 things about that. Number one, she's talking about political pressure. She even said, I did not want to stand in front of a lectern and tell people we were going to take our time. And you know what? If you're going to be the police chief, you stand up there and you take the hits and you tell people you're going to stand up for due process. The second thing I will tell you is there's 4 words on the front of this United States Supreme Court. It says equal justice under law. And that means that it doesn't have to be convenient. It means that it doesn't have to be politically expedient. It means that it doesn't have to shaft you from ever getting another job in law enforcement as the chief. It means that your obligation is to stand up for these officers. And the city of Atlanta oath, and the chief knows this, says she's supposed to respond and abide and enforce the policies and procedures and ordinances of the city of Atlanta. But they went out the window because it was inconvenient for someone to admit that 2 college students committed an obstruction, refused to get off the roadway, and decided it was more important to be a jerk to 4 uniformed law enforcement officers than it was to be responsible citizens in the city of Atlanta. They drove away. You can see it in the video. They not only just refused to move, they were blocking other traffic, And when they did drive away, they almost pulled Sergeant Hood off of his feet. If he hit his head on the ground, if his leg got run over, he could have been seriously, seriously injured, and they made a decision to take him into custody. Not the first time he refused to leave, not the second time he refused to leave. And if you look at the video, you can see Miss Pilgrim standing outside the car after they were told to leave. She actually got out of the car after they were told to leave. And I understand the time frames. I just object to the fact that we have been pushed, but I'm just going to ask the three of you a question. You've taken an oath. I know at least two of you are members of the bar. Ms. File, if you are, and I have not given you credit, then I apologize. But you know, one of the things that we have to do in our jobs is to have courage. And I am hoping that you have the courage to say to the city of Atlanta, abide by your policies. I am hoping that you will give due process its fair day here, because this is all he has. The day that he put that uniform on to work a 21-hour shift after having worked numerous shifts, after having people throw rocks and bottles and bricks at him, and people throwing mortars at him and trying to kill him, he went to work confident that he would be entitled to due process and a fair shake from this board. And that means, even if you don't like what he did, put him back to work, give him his back pay, reinstate him. Even if you want to say to the city of Atlanta, follow your policies, do an investigation. Do you realize that we are some 6 or 8 months past this incident? And for the first time, somebody has asked him why he drew a gun. For the first time, somebody has asked him why he deployed a taser. And all you heard when we were going to see these videos from the city is, he's the one with the gun. He's the one with the gun. You know what? When you have somebody refusing commands and they're pulling something out of their pocket instead of showing their hands, this is not some pacifist college student. This is somebody who is intentionally escalating, refusing commands, and committing an obstruction. I'll tell you who was in control of the situation from the get-go. It was Messiah Young. Drive your car away. Even better, do you know how to tell time? It's 21:50. It's 50 minutes after the curfew expired. You're not supposed to be there at all. Have the courage. I am asking you to have the courage. Look at this testimony and say to the city, yes, you can police your officers. We want you to police your officers, but do it right. And here's an idea. It's hard to even say this. Tell the city of Atlanta to follow the law. Thank you.
So, Ms. Lawrence Hardy, for the last time, your turn.
Thank you, Madam Chair. I want to encourage the board to watch the video footage. You know, it's interesting when I hear Mr. LoRusso, I sometimes think we must be watching different footage because I have such a different experience watching it. And Chief Shields clearly had a different experience watching it. I want to remind us that she said she spent a minimum of 4 hours reviewing the footage. As you can see, there's not a lot of footage. The incident was over quickly, right? We spent 15 minutes looking at different body cams of the same image. She watched it over and over and over again, very thoroughly, longer than we've been here together today. And I know we've been here together for a while, but she took that time and went through it before making the decision. Chief Shields had not just the authority, right? She's the appointing authority, had the authority to make the decision. And she's the only one under the code given that authority. She also had the responsibility to act to keep the city safe. She told you she did what she felt she had to do to keep our city from burning. And it is a good thing to be here on this side of it without things escalating as she feared that they would had she not acted promptly. So there is the courage. Mr. LoRusso referenced courage. I was impressed to see the courageous leadership she showed in making this decision. And I hope that the board, we ask that the board uphold her decision. Thank you.
Thank you, everyone. The hearing is now closed at 2:04 p.m. A decision will follow within the next 30 days. It will be sent via email, so make sure your email address is up to date with Ms. Harmon. Thank you. The hearing's closed.
Thank you.
Is Ms. Harmon still here?
I am.
Hey, I think I'm on the next one that's supposed to happen.
Yes, ma'am. Okay. Hold on just a quick moment.
Okay, okay, sorry.
Yeah, we're gonna try to start at 2:30.